Morning, everyone. We will call this meeting to order. And looks like we've got our Zoom members joining us up there, which is good. First thing on the agenda will be for all the legislators to identify themselves. So I would first ask those on Zoom to let us know who's on this morning. So just whoever wants to jump in.
Assemblyman Kevin Cahill from New York.
Assemblyman Ken Cooley in California.
State Senator Bob Hackett from Ohio.
Representative Joe Schmick from Washington.
Representative Wendy Thomas from Pennsylvania.
Thank you. Any other on Zoom that we've missed? Okay. Hearing none, we will switch to those in person. So if you would identify yourself, please.
Representative Mike Weber from Michigan.
State Senator Andy Zay from Indiana.
Thank you. We've got a couple back here on the right.
Representative Joe Fisher, Kentucky.
Senator Sean Vita, North Dakota.
Representative Bart Rowland, Kentucky.
Thank you, everyone. And I'm Paul Utke, Senator from Minnesota. First thing this morning, we need a motion to waive the quorum. So I'd entertain a motion. We have a motion and a second. Second, okay, thank you. All those in favor of the motion signify by saying aye. Aye.
Aye.
Opposed? Thank you. Motion passes. And now we've got our meeting minutes from September 25th, 2020. I would entertain a motion to approve those. We have a motion. Is there a second?
Second.
Second? Okay, thank you. To that motion, all those in favor signify by saying aye.
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 Opposed, same sign. Motion passes. Thank you. Okay, members and those in attendance. First item on our agenda this morning is ABCs of Experience Rating. We have Gerald Ordoin, Director of Experience Rating from the National Council on Compensation Insurance. And Gerald must be joining us online.
Yes, sir, I am.
Okay, welcome to our committee.
Thank you.
Go ahead when you're ready.
Well, good morning, everyone. Thank you so much for inviting me here today to do this brief presentation for you. I'm going to try to share my screen here. So, let's see. Can you see the title slide that I've put up? Yes. Okay. Thank you. Sorry, I'm a little bit new to Zoom, so I was hoping I was going to do this right. So again, thank you very much. My name is Gerald Ordon. I am the Director of Experience Rating for NCCI. I've been with the council for, I would say, almost 25 years now. And I've been working with the Experience Rating Department for the vast majority of that time. Just as kind of a little bit of a level set, what I'm going to talk about today as it pertains to experience rating is really NCCI's experience rating plan. So as I was listening to the roll call, I think there's a number of folks that are here in the audience today that may be in some states where this plan may not apply, but I think the general concepts of experience rating are pretty similar across the different jurisdictions. But I'm going to be really speaking about the specifics of NCCI's experience rating plan and how it works within the pricing of the workers' compensation insurance program. So go ahead and start making my way. So experience rating is designed to recognize the differences among individual employers with respect to safety and loss prevention. It does this by comparing the experience of individual insureds to the average insured in the same classification. So comparing roofers to other roofers, clerical to other clerical, retail to other retail, things such as that. Those differences are reflected in the experience rating modification factor, and it's based on the employer's individual payroll and loss records. And that mod factor could result in an increase, which we call a debit, anything over a 1.0, a decrease, which would be a credit, anything under a 1.0, or potentially it could calculate out to be exactly 1.0, which would mean there'd be absolutely no change to the premium that the employer happened to be paying for their work comp policy. If the rating system went no further than simply manual rating, so those manual loss costs or that manual rate that the carrier was applying to the different exposures, then potentially, insurance providers could simply seek out those employers that they expect to have better than average experience and avoid those employers that maybe had worse than average expected cost. So the experience rating mod is really designed as a part of the overall pricing of workers' compensation. Okay. So as I said, as part of this presentation, I'm really going to be talking about the NCCI Experience Rating Plan Manual. So in this map, you can see, and I'm going to highlight first, those states that are highlighted in blue. So those 35 states in the District of Columbia are, what we call the NCCI states. So those are the states that participate in NCCI's Experience Rating Plan Manual on both an intrastate and an interstate basis. Now, the difference between intrastate and interstate rating basis is that if an employer had a single location, let's say in one state, and that was where their operations were, let's say in Oklahoma, well, they would be intrastate rated with just their Oklahoma experience. But if perchance they had operations in 2 or more states, and those states are both the states in blue and in green, then they would be interstate rated. The green states you see there, Minnesota, Wisconsin, Indiana, North Carolina, New York, and Massachusetts, have their own independent rating bureaus in those states that handle the intrastate rating portion for those employers, but they do participate in the interstate rating plan. So if, let's say, a business owner had operations in both North Carolina and South Carolina, NCCI would calculate a single modification factor that would apply to their exposure in both those states. So to their premium in both those states would apply that single mod factor. And that would be true of any combination of the 42 blue and green states that you see here in the map. The purple states are the other independent bureau states that have their own independent rating organizations in those states, and they're not part of the interstate rating plan. So they're calculating a single state mod for all employers that do business in that state. And then the states in orange are those 4 states that are monopolistic state funds, so they also do not participate in the experience rating, the interstate experience rating plan. So if, for example, an employer had operations in California and Nevada, California would be responsible for calculating a modification factor for the California experience, and NCCI would calculate a modification factor for the business in Nevada, the business operations in Nevada with just their Nevada experience. So some statistics on how and what NCCI does on an annual basis. So in 2019, we calculated over 1.2 million experience rating modification factors. And those 1.2 million modification factors were calculated for about 740,000 different employers. And of those employers, about 620,000 were intrastate rated employers, which means, as I said, they simply had operations in a single state. Another 120,000 were those interstate rated employers. So those are those employers that have multi-state operations across any combination of those 42 states that participate, those 42 jurisdictions that participate in the interstate rating plan. That's a lot of work for us to do. It's a lot of data that flows in to NCCI for us to calculate those mods. We have over the years implemented some systems clearly that do the calculations automatically. And for the most part, about 80% of the mods that we calculate are calculated really without any manual intervention. So the insurance provider submits the unit data, that audited payroll and loss records to NCCI. It goes through the upfront editing process. It passes over to us in the experience rating department, flows through our calculation engines, and we produce the mod factors and then distribute those to the necessary stakeholders that need that information, either from a carrier perspective to apply that modification to the premium, or in most states, also to the employer, so they're aware of what their modification factor is going to be for that current year. Additionally, we also look at ownership requests, and I'm going to go into a little bit more detail on ownership later in my presentation. But ownership requests are important because it's how we make sure that we're using the right experience in the calculation of the modification factor. And all the ownership information that flows through to NCCI is all reviewed manually by someone on my staff. So while we do have some automation around the calculation of the mods, the ownership transactions, because they can be a little bit more complex, all of that is reviewed by somebody, by an analyst here in my department. So how do we calculate the mod? So really, in its most simplified format, the experience modification factor is really a comparison of an employer's actual losses to their expected losses. So their actual losses are those losses that represent both the paid and reserved amount of any claims that may have happened in the experience period. And I'll talk about that in just a second. And expected losses are based on the exposure, or in most cases, the payroll of the employer. Now, the expected losses are really driven by two factors. One, the amount of payroll that the employer has, and then two, the type of business, the type of operations that the employer has. So clearly you would think that a business that a construction business is more likely to have claims than maybe like someone like myself who sits in an office all day. So the upfront rates are going to be higher for that construction company than they are for like an insurance company. But then also the expected losses are also going to be higher for that as well. So the expected losses, like I said, are based on both a combination of overall payroll. So the more payroll, the more expected losses you would expect that would be expected to be generated, as well as the type of exposure, what the possibility of risk is for that employer in that type of class code. So I said the term experience period. So in the experience rating calculation, we typically, and I say typically, look at 3 years of experience. And that is 3 years of experience that ends 1 year prior to the effective date of the mod that we're calculating. So for purposes of a quick example, as we're getting closer to the end of the year, for those modification factors or those mods that we're calculating that have an effective date of 1/1/2021, we're going to use a 3-year window that ends 1 year prior. So we're going to use that window that ended 1/1/2020. So we're going to be looking at 2017, 2018, and 2019 policy periods. So that 3-year window, because the 2019 policy would end 1/1/2020. So that 3-year window is what typically goes in to the calculation of the experience modification factor. Not all employers qualify for experience rating. In NCCI jurisdictions, qualification is based on premium, and that is the premium generated by those policies that are part of the experience period. So it's that 3-year window that I just described. And it varies by state. I looked just earlier this week. The average experience, the average premium eligibility across the NCCI states is about $9,500 in premium annually. But it ranges from as low as 5,500 to as high as 13,000. So there are those state differentials there that come into play. And the other thing I want to mention here is starting in 2017, in most states, that premium eligibility is now indexed. So it has the possibility of increasing as time goes on. It's tied to the US Bureau of Labor Statistics quarterly census of employment and wages. So that's looked at on an annual basis. And in some cases, some years in a state may see a rise in the premium threshold. And then in other years, they may not. But it's really done to kind of keep pace with inflation, to make sure that those employers that really are too small to qualify for experience rating aren't being included and being included in the calculation and getting a mod, because they probably don't have enough credibility to warrant getting an experience rating modification factor. So in the calculation of the mod, we talked briefly about how the expected losses are calculated, and that's based on the type of operations, class code, and the amount of payroll. The actual losses are based, as I said, on those actual paid and reserved claims that employer incurred over that experience period, that 3-year window generally. So those claims that go into the calculation, we break those claims into 2 pieces in NCCI's experience rating calculation. So at a point, which as of 1/1/2021, that split point is $18,000. So all claim dollars up to $18,000 are considered primary claim dollars. And they're going to go into the experience modification calculation at 100%, so full value. Any claim dollars over that $18,000 are going to go into the calculation, but at a reduced amount. And that reduced amount really depends on the size of the employer, so how much payroll they've generated over the years. And that amount can be as low as 4% or potentially as high as 80%, depending on their size. Oftentimes, when we talk about experience rating, we use the term frequency versus severity. And what that means is it's this primary versus excess portion of the claim. So the primary portion represents the frequency, and the excess portion represents the severity. Frequency plays a greater weight in the mod calculation than severity. The fact that the claim happened and the claim existed is more important than what the overall claim dollars are. Now, that's not to say the overall claim dollars aren't important, but they're not quite as important. So for example, let's say an employer had a $50,000 claim. Well, $18,000 would go in at 100%, the first $18,000, and those dollars over $18,000, that additional $32,000, would then go in at a reduced amount. So let's say, based on their size, that weighting factor was 10%. So that $32,000 is only going to go into the mod calculation at $3,200. So that $50,000 claim in the mod calculation is really going to look like $21,200. The $18,000 primary and the $3,200 excess. The split point, much like the premium eligibility threshold, is also now indexed. It can be indexed annually. This was some research that was done by our actuarial department in the early 2010s and went into effect in 2013. And we moved what had been a very static split point and indexed it over a couple of years to what the appropriate amount was, which was around the $15,000 mark. And now it's been indexed based on inflation annually since then. Like I said, as of 2021, in most states, that split point value is going to be $18,000. So we take those claims and we break them into primary and excess. But there are also some other limitations that can occur to a claim. So in most states, if the claim is medical only, then the claim dollars are going to be reduced by 70%. So for example, if an employer had a $2,000 medical only claim, so there was no lost time, it was simply a stitch, and the employee had to go to the emergency room, got some stitches. They didn't lose any time, let's say, they didn't lose any time away from work. That would be a medical only claim. So that $2,000 claim will then only go into the mod calculation as a $600 claim. So it's going to be reduced by 70%. Every state has a state per claim accident limitation. So as I said previously, we have kind of frequency versus severity. Well, there gets to a certain point where a claim can get up to be of such size that any dollars above a certain level aren't adding value to the mod calculation. And again, that dollar amount is based on state. It's based on the state, the data that the actuaries look at as part of the annual loss cost or rate filing. And it can vary anywhere from $150,000 to $500,000 based on the state, individual state data. For 2020, currently, it looks to be about, for most states, around $275,000. So if, for example, an employer had a very unfortunate claim, and that claim was $500,000, with that claim in a state with a $275,000 state accident limit would be capped at $275,000. So the $225,000 above that $275 cap are going to be excluded completely. So $18,000 of the claim is going to go into the mod calculation at full weight, 100%. That difference between 275 and 18,000 is going to go in at a reduced amount depending on the employer size. And anything above that 275 is just going to be discarded and not used at all in the mod calculation. There's a secondary claim limitation. There's a state multiple claim limitation. And this is an added layer of protection for employers. If, for example, there's a single accident where multiple employees happen to get injured, an explosion in a warehouse, or employees traveling together to a work site and they're involved in a motor vehicle accident. So in that case, potentially, those claims would then be, all those claims grouped together would then be limited to a value, and that value is 2 times the state accident limitation. So if the state has a 275 individual claim accident limitation, then the combination of all those claims in that single accident would be limited to $550,000 in the mod calculation. And that's important because, again, it adds another layer of protection for the employer. Clearly, there's been a lot of talk for everything, but in the workers' comp arena around COVID-19 and the impact it could have on workers' compensation. So as far as from an experience rating perspective, a decision was made earlier this year, and a filing was made which resulted in an exclusion of COVID-19 claims from the experience modification formula. It was felt that actuarially, this information probably didn't add a lot of value because it wasn't going to be a great indicator for potential claim activity in the future. Like we expect, hopefully, COVID to be, once in a 100-year type of event, a pandemic. It's not likely that that same type of claim activities are going to occur in 3 years for that same employer. So that filing was made, and any claims that are reported, specifically with certain identifiers that were created to identify that claim as a COVID-19 claim, and that happens to do with the accident date. It must be after December 1st, 2019. And it has to be there's some other identifiers on that claim that would then result in that claim being excluded from the workers' compensation, the experience rating modification formula calculation. Something similar was done many years ago to the unfortunate 9/11 attacks. All claims associated with that were also excluded from experience rating. for much the same reason. There just clearly wasn't the expectation that that was going to be a good indicator of future claim activity in the near future. And finally, as the final layer of protection for that individual employer, there is a maximum debit modification that could be applied. So this is a cap on the mod that would really limit how high the mod could go for an individual employer. And it's based on size, but it's really a protection there for those smaller employers that maybe just qualify for experience rating and just happen to have a couple of unfortunate claims during that experience period. So it puts a cap on that mod, and that cap starts at 1.10 and grows based on the size of the employer. So I said earlier that we were going to talk a little bit about ownership. So we do collect ownership information on employers. It's up to the employer to submit that data to us. And it's important because experience rating uses the past experience of the business to calculate the mod factor. So it's appropriate that we use all of the experience of that employer. And changes in ownership could impact the experience that's used in the mod calculation. And for purpose of experience rating, that past experience could be transferred or combined in the mod calculation. And ownership changes can be, they vary quite dramatically, from as simple name changes to sales, or some really very large mergers that we've dealt with, or purchases, acquisitions of large companies, as well as new entities being formed that would then potentially that experience would be used in the calculation of other businesses. So as an example, kind of a basics example. So here's an example of 3 companies. And in each example, owner A owns a majority of the business. So company 1, company 2, company 3, owner A owns more than 50% of each business. So based on NCCI's experience rating plan manual rules, because that person, and it could be a person, an entity, another company, whatever it happens to be, group of people, because that person owns more than 50% of all 3 businesses, then the experience of all 3 businesses are going to be combined to calculate a single modification factor that would then apply to all of the businesses. And that's true regardless of the type of operations, regardless of how varied those operations might be across those 3 companies. All that experience is going to be pulled together and calculate a single mod, because that one person, that one entity happens to own a majority of all 3 businesses. The next ownership example I would like to give is a sale. So I own a company, and then I sell that company to someone else who wants to start operating that business. When that transaction takes place and that business is sold, that experience that was generated while I was the owner, that experience then transfers to the new owner, because the operations haven't changed. So that new owner is just taken over those operations. So they're going to get that new experience. So they're going to inherit that new experience. So when that second person buys that company, not only are they buying the company, but they're also in essence buying the experience as well. And in this case, let's say person B happened to own another company prior to buying my company. Well, now we're going to calculate a combined mod, because just like we saw on the prior screen, that person, he or she now owns multiple different businesses. And finally, I would just like to point out that this was a very high-level overview of our experience rating program. We have a lot of other information available on NCCI.com. You can go to NCCI.com, top banner, the Learning Center. There's a whole series of information. All of this is in front of our authentication. It's available to anybody, employers, agents, anyone. They could go in and they could look at this. We have a number of different webinars, each about 15 to 20 minutes long, that take you through different levels of detail in the experience rating calculation, in the actual experience rating worksheet, how ownership transactions work. And we also have a document out there that has been very, very popular over the years, the ABCs of experience rating, which really goes into a lot of detail. And I can tell you in many cases where someone has come and they've asked questions about what is experience rating, I typically provide that document to them and say, take a look at this. And if you have any questions, I'll be more than happy to follow up. And in many cases, that document does tend to answer most questions that people do have. So that is my presentation. I don't know if there are any questions, any topics I didn't go over that maybe I should have.
Thank you very much, Gerald. We do have a question in house here. Representative Lehman.
Thank you, Mr. Chair. The question goes to a couple of things that I think over the years I've always wondered how NCCI takes into consideration, and it actually had an effect on one of my clients. They're a trucking company. They were in a not at fault accident in the course of employment, paid out about $350,000. It's going to be fully subrogated. The other carrier took on the obligation, but in the meantime, that was 2 years down the road. Because it was paid out under workers' comp, he gets a $350,000 and it was under the cap. So basically, his mod went up about 35 points to the cost him about 25 grand a year. Fully subrogated, the company got all their money back, but they're now on the hook for the next 3 years paying that mod. Even if it's adjusted to their current, it's still not going to hit their mod till that delay. So has the NCCI looked at two things really? One is the subrogation issue, and the other is on the reserving, because we also see in the market, you'll have a claim set up and they'll reserve it for $250,000, and if that doesn't get settled, adjudicated, that then hits their mod at a $250,000 claim. It actually gets paid out at like $50,000, but they're paying their mod based on the $250,000. So how has NCCI kind of threaded that needle of how do you handle subrogation and how do you handle reserving in both situations where they drop significantly well into their already paying for their mod?
Thank you, sir. So let me touch on a couple of different things. So from a subrogation perspective, there are specific rules in the experience rating plan manual that if a claim is subrogated, the carrier who, like in this example, your client's carrier who had paid the claim originally, once that subrogation dollars are reimbursed, they should be, and again, based on the rules in the statistical plan and the experience rating plan manual, they should be submitting correction reports, which are then lowering that claim value down to just whatever the difference was that wasn't subrogated. So that I think the example you gave was a $350,000 claim. So if all of that was reimbursed in time, they would submit correction reports back to the first report level. So back to that original reporting. And then we would, NCCI would then be able to go back and revise that prior mod that had used that $350,000 claim value. We would then revise that mod with the reduced claim value.
So if they're like in year 2 of their mod, so that's the year it hit. If that gets readjusted, their mod would actually drop in that same year or that following year. They wouldn't be tagged with that 1.35. They wouldn't have that catastrophic loss in that 3-year window, the whole 3 years. You're saying they could actually go back, readjust that, and then that would affect their ongoing mod.
Yes, sir. So there are a couple of things. So for correction reports, and this goes back to the slide I had up earlier about the 1.2 million mods and the 740,000 employers. We are revising mods because we're getting updated data from carriers. Rate filings are being approved. So for any reason in most states, we will revise the current mod, so the mod that's in effect today, as well as the prior 2 years mods. That's true for any reason. For subrogation, that time period actually expands for potentially up to 5 years. So it would be the current mod and then 4 prior. So in this example, once that subrogation was worked out and that carrier got that reimbursement, they should then potentially report that they should be reporting the correction report, which would then trigger revision. We at NCCI would then trigger the revision, which would revise the client's mod, dropping not only today's mod, the mod that they're paying today, but the prior year, potentially if it was on the prior 2 years of all 3 mods.
And is that triggered by, if that subrogation is successful, they've gotten 100% of their money back, is that their obligation to trigger that with NCCI, or does the insured have some obligation to request that?
Once the carrier submits the correction report with the revised claim dollars, that will automatically trigger it within that initial 3-year window. If for some reason it goes beyond and it's within the 5-year window, there might be some communication we need from the insurance provider, but the insured there really shouldn't be anything the insured needs to do. Clearly, I mean, if they're not seeing that happen, they might want to raise that up to their agent to make sure that everything's being taken care of. But yeah, the submission of the correction report by the insurance provider would trigger the revision to the modification, which would then lower the claim value.
And then on the reserving issue.
So that was the second thing. And all I can say is that NCCI cannot respond to questions on carrier practices, especially when it comes to reserving. So I have no basis to even have that conversation. I'm sorry.
Okay, thank you. Representative Rowland?
Thank you, Mr. Chairman. And a follow-up to Representative Lehman's question that I found interesting. With subrogation, you have a 5-year window, current year plus the 4 prior mod years. If you adjusted the mod down in the 3 or 4 prior mod years, would the carrier be obligated to adjust the premium and refund the customer based on the lower mod?
Sorry. Yes, sir, they would, because that's within NCCI's Opinion Trading Plan Manual rules, that because that mod was revised within the revision window as defined in the plan manual, then that carrier would then have to issue that refund.
I learned something, Representative Lehman.
Do we have any questions online with our Zoom attendees?
Can an interested party ask a question? My name's Jeff Klein.
Okay, just make a quick one, and then we're going to move on to our next section.
Okay, I'm sorry. I just wanted to ask Gerald if occupational disease is treated the same way.
I did not get into occupational disease. There's a whole separate claim limitation for occupational disease that's a little bit more complex, and we typically don't see that much of it. But yeah, I mean, claims for occupational disease would go into the mod calculation, and then there's another whole layer. But like I said, it's not very common, so I didn't want to get into it. I thought that was a little too deep into the weeds for this presentation.
Well, thank you very much, Gerald, for joining us this morning. Learned a lot about what goes into these modifications. And I did have a note that I was making, but you covered it well, and that was COVID going to affect the experience rating? So that was good to hear. So again, we appreciate you joining us this morning. Thank you very much.
Thank you. Thank you so much for inviting me.
Okay, members, we'll move on to the next item on our agenda. Discussion on Florida's workers' compensation insurance marketplace responses to COVID-19. And we are going to start, our speakers are going to be just in the reverse order that they're showing here in our book. So Jeff, is it Bichler, is going to join us first, and I believe that's online.
Yes, Mr. Chairman, this is Jeff, and it's Bichler. The last name is pronounced Bichler.
Sorry about that.
That's quite all right. It's very common mispronunciation. Yeah, so appreciate really very much the opportunity to be with you today. We've got to put this sort of interesting group together. Our Chief Judge, Judge Lang, is going to speak later, and Yashika is going to speak from more of a defense perspective as it relates to what's happened with the COVID issue in Florida. And I think really this is something that it really is more of a national discussion anyway. So I recognize that we have legislators here from all over the country, and I think this is a important and a very good discussion to have. Interesting to hear from NCCI on the experience rating issue related to occupational disease, because that's really what we're talking about with COVID. And I know there's been, a lot of uncertainty, certainly dating back to the beginning of this pandemic about how these claims are going to be handled. And I think we can shed some light, at least as it relates to what's happened in Florida. And hopefully that'll be instructive for you in your various states. I would note at the outset, I got up this morning and I was reading the paper and having my coffee. I guess the federal COVID fiscal relief package now is currently tied up largely due to the liability protection issue and immunity that is attempting, that the legislature is attempting to create related to COVID claims. So, when we start diving into this issue, we recognize how complex it is and really how important it is for stakeholders, as regardless of the state that you may be in. The starting point for us, I think, is always going to be the state workers' compensation statute. So my first slide, I think if I can share my screen here, actually will show us, if you can just click over. This is our, a portion of our statute relating to occupational disease and exposure. We have a very, very stringent standard in Florida prohibiting claims for toxic exposure and injury or disease. As a matter of fact, in 440.02, which is our definitional section of our Workers' Compensation Act, it actually excludes from coverage exposure to a toxic substance unless there are a number of factors with clear and convincing evidence establishing that the exposure to a specific substance involved at the precise levels to which the employee was exposed can cause the injury or disease that has been contracted or the exposure that has been sustained. This standard has been in place since 2003 reforms to our Workers' Comp Act and have really created a lot of problems for injured workers who have attempted to bring these types of claims. And so you don't see that many of these types of cases being brought. Maybe, again, why NCCI said this is not an issue that they see too commonly, because I think most states have similar, very restrictive language related to occupational disease and exposure claims. So really, that's your starting point, and I think it has to inform any consideration of liability or immunity or additional legislation that you may be looking at to try to limit claims related to COVID. And moving to, and the one other thing with respect to Florida law, we have a specific occupational disease provision, which is in 441.51, that just sort of parrots a lot of this language that you see in this definitional section. But bottom line here is that it's just very, very restrictive and difficult standard. A recent appellate case, and we were all waiting for this decision to come out. The timing actually was very interesting as it relates to the COVID issue. If you'll move to the next slide. This decision came out of our appellate court in Florida in late November of last year, with rehearing denied in January, just before we started to see COVID cases in Florida. This involved an occupational exposure and a death claim. And we have a concurring opinion here and Judge Wolf is a very prominent jurist in Florida that features regularly in constitutional decisions in Florida. He said this case and Gideon reject the use of overwhelming circumstantial evidence to prove the statutory requirements of clear and convincing evidence in toxic exposure cases. Direct proof of the level of exposure to the toxic substance is simply not available in a great number of toxic exposure cases. He goes on to say, I'm therefore not convinced that workers' compensation is a viable alternative to the tort system for workers that are injured by toxic exposure in the workplace. Either the court system or the legislature must address this problem. So for me as an advocate, and I didn't introduce myself properly, I represent injured workers and primarily first responders in Florida. So the vast majority of my practice involves a representation of firefighters, police officers, and corrections officers. This was a reversal of a trial judge order that actually found in favor of the widow of this worker who died following a very clear exposure to a toxic substance in the workplace. And the evidence was overwhelming, as the judge notes here. And the trial court found in favor of the worker, the appellate court reversed, and then we get this language out of the appellate court saying this may not be a viable alternative to tort remedies. So, you know, from our perspective in Florida, again, we're on a very thin edge between what may be constitutional and not constitutional in these types of circumstances. So when we started looking at this and recognizing the court decisions, when the COVID pandemic began, we knew that we were going to need special statutory protections. A lot of states have implemented presumptive legislation. I know that's quite controversial, but we here in Florida do have a history of passing presumptive legislation to protect first responders. So we started working early in the process to see if we could get a presumption passed. We went to the governor's office to see if we could get an executive order. He did not issue an executive order, but our CFO, Jimmy Petronas, did in late March. And his executive order essentially advised the state agencies and employers in the state of Florida that they should recognize these claims as presumptively work-related. Now, again, that wasn't binding, but it was something that a lot of our employers in Florida recognized and agreed that essentially would be the right thing to do to recognize these claims of first responders that were diagnosed with COVID as being work-related. So that was kind of the first thing that we saw. At the same time, the federal legislation was moving related to the public safety officer benefit. Some of you may be familiar with that legislation. It provides for death benefits and some limited disability benefits for first responders who are injured or killed on the job. The Congress did pass this legislation. It went into effect in August, and recognizing COVID as presumptively work-related, at least with respect to death claims. So, you know, the language there was also something we thought could be beneficial in Florida, bringing claims on behalf of firefighters and police officers. And that again passed in August. We also proposed our own legislation. Now, this is something that in Florida, we have our special statutory protections for first responders, and they're in Chapter 112. And so what we did there for some of our union leaders was create a template that they could use to try to go find sponsorship to pass legislation that would provide basic coverage for coronavirus cases with the ability to rebut the presumption, you know, in certain circumstances where you could demonstrate the condition was contracted someplace else. Now, again, because of the timing in Florida, we have limited legislative sessions. We were in the middle of the pandemic during our session last year. It ended. There was no opportunity to pass this law last year, but there is interest again in potentially doing it this year, and with the numbers going up in the way that they are, we still feel like this would be a good approach to the issue to make sure that our first responders are getting covered under the Workers' Compensation Act for these types of conditions. I would note at the same time that we're pressing on that issue, we have this task force in Florida that Associated Industries of Florida is pushing primarily to restrict liability. This is very similar to what we're seeing, I think, at the federal level, where they want to really just immunize employers, I think, and companies more generally from liability claims related to COVID. And it's problematic from our perspective, just from a civil liberties standpoint, that you would not allow somebody to bring this type of claim regardless of the circumstances. And I think that may be where the rub is coming, in Washington right now, is, that there's this sense that there's a need to protect employers and that may not be real. If you're looking at the legislation that exists in most of our states, it's so restrictive that it's very difficult to prove these cases anyway. And I would say, as we were, just to kind of wrap this up, at least my portion of this, in speaking to Judge Langham and in speaking to Yashika about this problem, once this case was decided in November of last year, most attorneys that represent injured workers pretty much gave up the idea that you could prove an occupational disease or exposure case. I mean, we really feel that the standard is so difficult at this point that those claims are essentially they're suicide missions. If you're going to take this on, you're not going to be able to meet your burden, so you're likely to lose the case. And so I think each of you in your respective states have to look at the precise language related to exposure and occupational disease, and then make a determination, how difficult is that standard, and do you really need to do anything additional to protect employers from liability? I would suggest no. I would say, just based on the numbers that Judge Langham has shared, about half of our claims in Florida are being accepted. And that's shocking to me, because I really don't think, given the legal standard, that any employer would have to recognize COVID as being work-related. Now, it's encouraging to me that roughly half of those cases are being acknowledged, and it seems as though employers and carriers are attempting to do the right thing, in various circumstances. But I guess I would leave you with that. My sense of it is, this may not be the sort of pressing issue that it seems. And each of your individual states, I think, will have their own determination related to the compensability of these types of conditions. So with that, I'll pass it on. I guess Yashika is going to go next, and thank you again for the opportunity to be here today.
Yeah. Thank you, Jeff, and please stay with us. We'll have our next two speakers, and then we'll take questions if there is some. So once again, thank you. And next up, we've got Yashika Williams, and again online. So welcome to our committee this morning.
Good morning. Thank you. Can you hear me okay?
Yes, we can.
Oh, great. It's an honor to be here today. So thank you very much for providing me with the opportunity. Just to give you some background about myself, I've been practicing for the last 17 years. For the last 15 years, I've been focusing on insurance defense, primarily workers' compensation. And so it's an honor to be here today to speak with you about COVID and its impact on workers' compensation. And thank you, Jeff, for laying out such a great outline of how COVID kind of intermixes with workers' compensation and how those claims can be found to be compensable and the standards that are applied. When I think about 2020 and COVID, I think this has definitely been the year of change and adaptability, right? We have been thrust into this new world of remote working, presenting from our offices, and just having to adapt to the change in the world. And so what I want to speak to you about is really how workers' compensation has adapted to the changes that COVID-19 has presented to us. So I'm going to share my screen as well and get started. When we first were put on notice about COVID, March 9th, 2020, Governor DeSantis issued a state of emergency and issued Executive Order 20-52, which essentially limited personal interactions outside of the home, services provided, and people's conduct. And at that time, many businesses, I mean, if you have a business that was had more than 10 employees, many of them closed. And for the most part, either they closed or they went to work from home. All of my insurance defense clients are remote, even still, and they've been remote since March, with the expectation that they will return to their offices sometime in 2021, I would say Q3 2021, on a graduated basis in order to ensure that they're able to properly socially distance and that they're able to keep their employees safe. Another thing that was really big with the executive order 20-52 is that it prevented elective surgery. And in most instances, that may not make a big difference. But when you're thinking about workers' compensation and your injured worker who's scheduled for an elective knee surgery or a back surgery or an elbow surgery or shoulder surgery, that was stopped because the governor wanted to make sure that surgeries could be done safely while not exposing patients and doctors to the potential COVID-19, but at the same time ensuring that if there was an issue as a result of COVID-19, that those facilities were able to quickly respond. And so, quite honestly, initially, with the delay in elective surgery, that also caused a ripple effect in workers' compensation. So think of it this way. If you have a person who's scheduled for surgery, say March 15th, the expectation is that they would be out of work for 2 weeks. So your expectation is you're paying them lost wages for that period of time, and then you're able to get them back to work. They're back to therapy, they're back to work, or back to having some type of restrictions that allows them to return to work and for the employer carrier to reduce its exposure. Well, if the elective surgeries are delayed, the doctors aren't seeing the patients, then what happens? Your exposure continues because your injured worker can't return to work, their out of work status is prolonged, and quite possibly their ability to recover from that needed surgery, although it's elective, it's still a surgery that's needed, it could also have a ripple effect in delaying their ability to recover long term. So about 2 months later, were some changes made, and even though we were still in a state of emergency, essentially an executive order was issued on May 4th, 2020, Executive Order 20-1112. And in that particular order, large groups were discouraged, and large groups at that time were any persons greater than 10 people. Bars, pubs, nightclubs, with more than 50% of their gross revenue from alcohol, had to suspend on-site consumption. So if you represent a district or an employer that's largely a business, for instance, you think garden companies or Outback companies or your local pubs and bars are small businesses, they are drastically impacted by Executive Order 20-112. So not only are they losing revenue, but you also have a diminished workforce, right? Because if you have a business that more than 50% is from alcohol sales and those sales have been stopped, and if they don't have sufficient menu to serve food, then they're more than likely they're not going to be open, or they're going to be open at such a reduced capacity that it causes significant loss. And at that time, capacity of restaurants is limited to 25%. Then June 5th, Executive Order 20-139 was entered. And this order was very interesting because what it did was it took a look at long-term care facilities. And if you have been watching the news, you know that initially COVID-19 really struck our long-term care facilities really hard. And so the governor said, we're going to mandate that those employees who are taking care of patients at long-term care facilities undergo routine testing. Well, that's excellent, because that means this is a way for us to stop the spread if there is spread, and to get those people treated and prevent people in the long-term care facilities from being exposed. Also, retail stores, gyms, fitness facilities were allowed to reopen as long as they were able to ensure social distancing and were able to sanitize the facilities. Then restaurants and businesses moved to 50% capacity. And so you can see, visualize that first you start out with everything pretty much closed for a period of time except essential businesses. And when you hear from Judge Lingham, he's going to talk, I'm sure, about essential businesses, and we all are essential. But at that time, we were thinking about your grocery stores, your pharmacies, sanitation workers, those individuals and those jobs being more so essential. But with this executive order too, the capacity was increased to 50%, and businesses really started to reopen. And then in September, we moved to the right to work phase. And this phase is where Governor DeSantis really got aggressive about trying to reopen businesses, getting the economy restarted after roughly 4 or 5 months, actually 6 months, 6.5 months of businesses being somewhat stagnant because of the precautions that we needed to take in order to slow the spread of COVID-19. And so what does that really have to do with workers' compensation? Well, a couple of things. In workers' compensation, if you are an employee who's paid primarily in cash or in tips, we rely heavily on your IRS filings to calculate what your average weekly wage is. And that's probably getting a little too deep for today. But the average weekly wage is used by the employer carrier and the claimant's counsel to determine how much weekly benefits, cash benefits the injured worker would be entitled to if they were out of work based on their work restrictions. Well, the tax deadline was extended from April 15th to July 15, 2019. So if we were relying on a person's income tax return or filings to determine what their average weekly wage was, there was no obligation for them to file prior to July 15th. So in that regard, you had some issue with trying to properly calculate what a person may be entitled to on a week-to-week basis. And then we come to the unemployment compensation. And as I indicated earlier, during the initial state of emergency in phase 1, many businesses were closed, many businesses were operating at a significantly reduced capacity. And so what I found in many of my employers who I represent, they were furloughing their employees. Many times not permanently, but at least for the short term. And so for those employees who were furloughed, they were not fired, they were furloughed, but they were allowed to apply for unemployment compensation. And so the question is, well, how does unemployment compensation directly impact workers' compensation? Well, under Florida Statute 440.15, subsection 10, it addresses a person's entitlement to unemployment compensation and unemployment compensation benefits impact on workers' compensation. First, if a person is on a no work status, but they've been furloughed by the employer because of having to run or operate at a reduced personnel, they would be entitled to unemployment compensation, which would include the $600 weekly additional benefit provided by the CARES Act. If a person receives unemployment compensation at any time in which they are on a temporary total disability work status where their doctor has said, sir, you're so injured, or ma'am, you're so injured that you are unable to work at all, you cannot receive unemployment compensation and temporary total disability benefits at the same time. And temporary total disability benefits are paid at 2/3 of the claimant's average earnings during the week. So the claimant is unable to double dip. Well, for the employer carrier, that reduces the exposure on that particular claim for as long as the person is receiving unemployment compensation. So what happens if you have a person who was on light duty or had work restrictions at the same time they were furloughed? they would also be entitled to unemployment compensation during that period of time. However, they would not be able to receive the full, at this point, is 64% of their average weekly wage in conjunction with their unemployment compensation. Unemployment compensation is primary. So the employer carrier would receive a dollar for dollar offset of the unemployment benefits received. Here's an example. If a person would normally receive an temporary partial disability benefit, $200 per week, as an example. But with unemployment compensation in the CARES Act, they were receiving $700 per week. Well, during that week of temporary partial disability, they would receive no monies from workers' compensation because they've been fully compensated by the unemployment compensation and receiving the benefit of the CARES Act. And so for me in my practice, the positives of the Unemployment Compensation CARES Act were that for many times for my injured employees, they weren't able to receive unemployment compensation and workers' compensation benefits at the same time, or the amount of unemployment compensation benefits they received were so high and that they weren't entitled to receive unemployment compensation, temporary partial disability benefits, which in turn reduced the file exposure on the claim. Another thing that we had to deal with in phase one and the emergency order were doctor office closures. You know, and at the beginning, we were all almost like ants scrambling around trying to figure out what to do, what should we do, what could we do, what couldn't we do, what was safe and what was unsafe. And so many doctors' offices had to close to kind of reset to make sure that they were operating in a way to protect not only their patients, but also themselves and their staff. I know of one medical practice in the Tampa Bay area that had one physician who actually contracted COVID-19. And as a result of that, the office, multiple offices in that practice group actually closed down for approximately 3 weeks in order to make sure everyone was safe, that it was properly cleaned and disinfected. And so that was a pretty big deal because it's a practice group that a lot of carriers refer injured workers to in the Tampa Bay area. Then you also had the component of injured worker fear. I've heard about this, disease that people are able to contract. It's airborne, quite possibly. I'm afraid to leave my house, or I don't want to go into a doctor's office because when I go to this doctor's office, I'm waiting in a waiting room for an hour or two before I see the doctor, and there are people coming in and out, and I could be exposed. So I don't want to go to the doctor. So what happens? In some cases, you're suffering with the situation where you have delayed care. But what I can say has been very positive in the workers' compensation practice in Florida, at least, is that many doctors have become more innovative. So we've seen an uprising of teledoc. And I know when teledoc was when I was first introduced to teledoc just through my own personal health insurance a few years ago, I was a little wary. Like, I don't know about how a doctor can treat me over the phone or over the iPad. But I will tell you that in this year, I've seen tons of physicians who are using teledoc to treat your injured workers who may have difficulty getting to the doctor's office. One of the things we found is that the doctors are more efficient. They're able to see more patients during the day. We're getting our reports quicker. And so that's a positive that has come out of COVID-19 and how this has truly been the year of adaptability, not only for insurance carriers, attorneys, injured workers, but also for physicians. I will tell you, every doctor hasn't been on board with teledoc, but for those that have, it has been a great way to keep your cases moving forward, getting the injured workers back to their pre-accident status, or at least as close to it as possible, and getting your cases closed quicker. You're also seeing where you have physical therapists are providing therapy via teledoc. And so that's another way to be innovative, because if you think about it, you go to physical therapy, there's 50 machines, at least 50 people there getting therapy from physicians. It's requiring close contact, of course, closer than 6 feet. People want to be safe. And so being able to perform or provide therapy via teledoc has been exceptional way to continue to get your injured workers healed and better and allow them to continue to progress in their claims. The only hiccup that I've seen with teledoc has been technology. You know, it almost presupposes that the injured worker has the necessary technology to get the benefit of teledoc. There are some vendors out there who provide that technology to the injured workers to assist them in having their teledoc appointments. And so it's very important that we rely on our resources. And that's one of the things that I think that COVID-19 has required of us, is to really work together as we using more of a collaborative model in the treatment of injured employees, where everyone is having to work together more collaboratively in order to move the cases through the system. So, you know, where do we go from here? What have we seen? You know, one of the things that I've seen is definitely enhanced cleaning and treatment protocols. If you have an injured worker whose case requires the assistance of a nurse case manager, or the injured worker requires translation services, you're seeing where the doctors have limited the amount of people who are allowed to come into the examining room. Usually if the person, say for instance, is Spanish speaking, you would have the doctor, the doctor's assistant, the injured worker, and a translator, or a family member who comes in to provide translation services. Not anymore. Many times you're having translators who are attending these appointments by phone, because the doctor is limiting the amount of people that are actually in the examining room at the same time. Nurse case managers who typically would attend appointments, maybe not be in the examination room with the doctors, but actually are going to the appointments to get information from the doctor so that the employer carriers are able to rapidly provide benefits that are needed and be aware of the claimant's medical status. Those appointments are being done telephonically, because again, the doctors are limiting the exposure in their offices. You're also finding that at the doctor's offices, they're doing temperature checks. They're doing waivers and questionnaires before the patients are able to enter the office. They're keeping injured workers in their cars or their vehicles prior to the appointment, so they're able to come from their car, temperature check, directly to the examination room, again, trying to limit interaction of people. So I've really seen that the doctor's offices and the medical providers are really adapting to the changes in a great way, because I haven't noticed a significant decline in the treatment that the injured workers are receiving. I had a case that went to trial back in May of this year, where an injured worker was authorized to see a physician. The injured worker felt uncomfortable because he wasn't comfortable driving to and from, based on it being a new physician office, and we offered to provide transportation services to the injured worker. Well, one of the biggest concerns that the injured worker had was, well, is this transportation vendor, am I the only person who's going to be in the vehicle? Will they have had time to disinfect the vehicle prior to my using and being transported in the vehicle? After they drop me off, will I have someone new pick me up? Will it be the same person? So there were a lot of issues and concerns related to transportation services. And so in that particular case, the judge actually ordered us to find someone who was closer to the claimant's home rather than the doctor that we had designated, because of his concerns with transportation and COVID. Again, the treatment options have been exceptionally innovative. Medical practices have been extremely flexible. But what I will note, what I have noticed since COVID has occurred, is there are less workers and less claims. I think what I'm seeing more so is the litigated claims that I have are more litigious, because attorneys are able to focus on those particular cases a little bit more than they were before. With reduced workforce, businesses closing, we're finding that there are a lot less claims being filed, a lot less new injured claims being filed, and those that are being filed are related to people who have pretty significant injuries. They're not your run-of-the-mill minor workers' compensation claims. They're significant, and they're significant enough for the person to want to file a claim versus dealing with it and keep working. And so what I found is there's been a lot less litigation, and Judge Langham will touch on this more, as well as far as how many claims have been filed since COVID has taken place. And one of the things that has been key, I believe, in the success of my practice has been communication. And as I've indicated earlier, with COVID, we've really had to handle these cases on a more collaborative basis, more communication with claimants counsel, more communication with the doctor's offices, more communication with the vendors who are helping us move the cases through the system, getting the claimants what they need so that they can return to work. And so to me, that's a positive. So some of the positives that have come out of COVID-19 and their impact on workers' compensation has definitely been telemedicine and the benefit of a person could be out of state and still see their doctor without having to transport them in and out of state. Being able to get the patient into the doctor quicker and get the notes quicker because doctors are being able to see patients more frequently and more succinctly. And also more of a collaborative practice in how we treat injured workers and how we move them collaboratively through the system. So for me, it has been a big change in my practice, but I think with this accepting that this has been the year of change and adaptability, I think we're going to be okay. And with that, I'll pass it on to Judge Langham unless there are any questions.
Thank you, Yashika. We will take and see if we have any time for questions here when we get done, but I do want to get to David Langham. He's the Deputy Chief Judge of Compensation Claims here in Florida, and we've got about 10 or 15 minutes here left to wrap things up. So welcome to our committee, and please proceed.
I hope that's on now.
You're good.
And thank you for having us. As way of introduction, to keep things brief, I've been wrapped up in this industry for about 30 years. I've never seen anything like COVID. I don't think any of us have. My main advice for those involved in regulating or legislating in this system would be that I think the ancillary effects, the tangential effects, are going to be far broader than the COVID direct effect. And I think that's where our minds need to be moving forward. What I've got for you is the figures of what's we've known about Florida moving forward. I'll remind you what Miss Williams just mentioned to you, that the state went back to full throttle. We were fully open in September. This curve from the latest annual report from the Division of Workers' Compensation shows that our big peak in COVID workers' comp claims was in July. We have seen since that time, even though we've been back open and running full throttle, is essentially a flattening of the curve. A lot of folks thought that when we opened businesses and everything went full power, that we'd have a lot more workers' comp claims. That simply hasn't come to pass. I would note for you that we've got 22 million people living in the state of Florida. These are only lost time claims, not medical only, folks, but that's 23,452. That's the total number of lost time claims we've had reported. That's the people who claim that they've suffered a work injury. I think that is exceedingly low in the grand scheme of things. We should think about that. The vast majority of those, I show you on this slide, the vast majority of those, 22,188, fall into a cost that is less than $5,000 to the carrier. They have a mean average cost of $703 each. Why is that? I think you can blame some of that, folks, on the fact that the federal government stepped in and provided greater unemployment compensation. I think you can blame some of that on Mr. Bickler's comments about how hard it is to prove a occupational disease case in this state. And so I think some folks looked at it and said, well, there's a tough hill I've got to climb, or I could take the unemployment comp. The unemployment comp was a benefit, and it was a good benefit, and I think a lot of those cases may be steered that way. I would point out to you, though, that at the bottom of this scale, although they're the vast minority, about 5% down here in this rest of the graph, some of these cases get very, very expensive. The mean average on those bottom six is almost $800,000 each. And where does that come from? I promise you, in the amount of time that has passed, the 10 months, it's not indemnity. I would assure you that money there is medical care. And that tells us that medical care for COVID cases may be very, very significant, and it's something we need to remain aware of. Where are they coming from? I compared for you here what Florida looks like in terms of our city population and in terms of where we're seeing those lost time workers' comp claims. Miami-Dade is by far our densest population center in the state. 31% of those claims are coming out of Miami-Dade County, another 8% out of Broward, which is next north, Fort Lauderdale. So almost 40% of the total in a portion of the state that has about 22% of the population. I would suggest to you that this supports that population density is important. I would also point out that it's not critical. You today sit in Tampa, Florida, that has 7% of our population and only 3% of those lost time claims. So it can be controlled. It can be better treated in urban areas. For some reason, it's just not being in some places. I wanted to compare the costs for you briefly. This is 31%. That is the percentage of those COVID lost time claims compared to all of our lost time claims in Florida this year. Wow, COVID claims are really a big percentage, folks, running 31.1%. But I would point out to you on the other side here, only 8% of the total expenditures. That includes those big claims that are $800,000 each. So I would suggest to you that this is a very broad and very important segment of our claims, but the cost on them is simply not today where you might expect them to be otherwise. I stress today, folks, because we need to get our brains wrapped around the fact that an awful lot of scientists around the world have come to the conclusion that there's such a thing called long COVID. The long COVID they're using to refer to the fact that we may have people who have bad health outcomes years down the road because of the exposure to this thing. We may be talking with some folks about lung transplants. We may be talking with folks about cardiopulmonary diseases of a variety of things. And so picking these things up as compensable today may create risks for these insurance carriers 5-10 years down the road. And I think that may be a part of this cost we're not seeing yet. Of that, 20,000, what was that number? About 25,000, only 45% of those have been denied. Anecdotally, we're hearing why have those been denied? That seems kind of high, about 45%. Well, it turns out an awful lot of those denials are based on negative test results. These are employees that have come to their employer and said, I'd like to report that I got COVID here at work. How do you know? Well, I've got this symptom or that symptom or whatever it may be. And then they get the test, and 10 days later, we get the test result back, and they're negative for COVID-19. Well, that's going to be denied, and rightly so. I think part of the flattening of that curve may, in fact, be that employees are not quite so rapid to report in today's environment, because for the most part, we've gotten around the state pretty good access to the more rapid test result. It's not a 7 to 10 day delay. So when someone's not feeling well, we're getting them tested much more rapidly. I think that's changing things. There's a disparity in the way the money shakes out. Our Division of Workers' Compensation chose to categorize all of those claims into these: the airline industry, healthcare, office workers, protective services, which includes those first responders Mr. Bickler alluded to, and the service industry. I would just point out to you that the numbers are not in parity everywhere. The office worker numbers are fairly closely tied: 10.6% of the claims, 10.7% of the cost. But if we look in protective service and healthcare, we see both an increase in a substantial number of claims, and we see that that's where the cost is running. I think part of that is something called the optimism bias that I would warn us about. We hear this time and time again about first responders and doctors. These people are trained professionals, and they have convinced themselves, many of them, that they're invincible. And that's a psychological occurrence that we just know occurs. They don't think they can be damaged. They keep charging into burning buildings. They keep charging into emergency rooms, and that's playing into this effect. Finally, I just want you to know that the denials are not all of the cost, not zero. So in the compensable claims, it's about $40 million we've spent so far this year. I expect to see that continue to rise. But those denied cases are almost $500,000. So even where we're denying the case and it's not moving forward in any real density in terms of expenditure, I think it's important for us to remember that there is cost associated. Employers and carriers are paying those costs to get the testing, to get the quarantine time and those sorts of things. So I gave you my email address here in case anybody's got questions. I had a bad feeling we were going to run out of time, and I think we pretty much have. I'd be happy to take any questions anybody has. The last point I would make is, of those cases that have been reported and are in lost time, Mr. Bickler thinks that it's in large part folks doing the right thing. I don't doubt there's some of that. It also occurs to me that some employers are picking up these claims because by picking them up, they get a healthy dose of what we call workers' compensation immunity. And I think that may be part of this. We do know that there are several cases pending in our circuit courts where employees are trying to sue their employers, and they're concurrently, we believe, in our workers' compensation system. So all of that, I think, probably wraps into an employer's decision-making process in all of this. And so with that, I yield back no time. I'm sorry. I've used every minute, but I appreciate being here.
Well, thank you very much. And you knew your two predecessors probably pretty well, so you knew you'd be squeezed at the end as far as your time went. But anyhow, we do have one question online that we would like to get to. Senator Hackett.
Yeah, and I'll be quick because I know you're under time. And I appreciate Mrs. Williams. You know, I hope the AMA was on. I just want to emphasize what she said and did a great job talking about telehealth and the ability that their providers are be able to see more patients in less time, that it is cheaper most of the time to do telehealth versus the inpatient office. So Mrs. Williams, thank you for making that point. And I hope all the other legislators heard that testimony. Thank you.
Thank you.
You're welcome.
And members, with that, we've reached our time limit, and we will be back right here in a few minutes at 10:45. The next session will start. So take a quick little break, and we'll see you in a few minutes.
Good morning and welcome to this NCOIL-NAIC dialogue on Friday, December 11th there in Tampa, Florida. And I'm participating from my home in Rancho Cordova, California. But I thank you all for being with us. I'm joined by my vice chair, Representative Martin Carbaugh of Indiana. So thank you, Martin, for anchoring the eastern end of this conversation. We find ourselves in the final month of NAIC President Ray Farmer's tenure. Ray has been with us throughout the last year, but he's not with us today. And we're very honored to have Florida Insurance Commissioner David Altmaier, who joins us. Just yesterday at the fall national meeting, he moved up in the officer ranks, and he will serve as NAIC president following the footsteps of Ray Farmer, effective January 1st. So Commissioner Altmaier, delighted to have you with us today. And I can assure you, I'm envious of all of you out there in the Sunshine State, as it's cold and gloomy and likely wet in this weekend in Northern California. We also have with us Insurance Commissioner Glenn Mulready, who's there, I believe, in Tampa. And David Altmaier is with us virtually. We also have Arkansas Commissioner Alan McLean, who is with us virtually today. He has a long history in the state of Arkansas on related matters. He's been the commissioner since the spring, and we're delighted to have Commissioner McLean with us today. We were going to be joined by Commissioner John King of Georgia, but he is in the National Guard, a major general, and has been tasked to travel to New Mexico to perform a mission in New Mexico among the Navajo people. So we wish him Godspeed on his journey. So with that, I call this meeting to order of the NAIC NCOIL dialogue. And I would ask lawmakers on the call on Zoom to please identify themselves for the record.
Kevin Cahill, New York.
Jim Gooch from Kentucky.
New York.
Very good. We have Mr. Cahill, Mr. Gooch, Mr. Seward.
George Kaiser, North Dakota.
Thank you, George.
Joe Schmick, Washington.
Joe, thank you very much. Thank you for your participation. It's an early hour when we're on here, George.
Bob
any
Hackett,
other-
Ohio.
Very good.
Wendy Thomas, Pennsylvania.
Very good, Ms. Thomas. Any other lawmakers online?
Peggy Mayfield, Indiana.
Thank you, Ms. Mayfield. Any other lawmakers online? Then those lawmakers present in Tampa, please identify yourselves.
Representative Matt Lehman.
Representative Mike Weber.
Very good.
Senator Mike Gaskell, Indiana.
Senator Travis Goldman, Indiana.
Representative Carbaugh, Indiana.
Very good.
Senator Sean Vita, North Dakota.
And Martin, does that conclude our attendees on the Tampa end?
Yeah, that looks like it.
Very good, Martin. Thank you very much. First order of business then, can I get a motion to waive the quorum in a second?
Second.
Moved and seconded that we waive our quorum requirement for purpose of this meeting. All those in favor signify by saying aye.
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 Those opposed? We have, that motion passes. We have waived the quorum. And can I get a motion to adopt the September 25th, 2020 committee meeting minutes?
So moved.
Second.
So moved and seconded. All those in favor of that, say aye.
Aye.
Aye. Opposed? Very good. Well, thank you all for joining us and for our regulators for their participation. And again, Commissioner Altmeyer, congratulations on the role you step into at this time. We have a lot of important issues always, but it's a little challenging at this time. So welcome.
Thank you.
Yes. Okay. Very good. To start today, we want to take up just an update on the NAIC credit for reinsurance models. Obviously that's been a major project of the NAIC to update that reinsurance model and to ensure that we have adoptions around the country to support continued strong state-based regulation and avoid issues of preemption arising from the covered agreements between the US and European Union and the covered agreement between the US and the UK. We've been tracking the progress. I think at this time we have 28 states which have adopted it. My own state, California, passed it earlier this year. And let's go to that. So this is, here we have depicted, I'm trying to read the fine print. This is the latest incorporation. Martin, can you see what is the difference between the top panel and the bottom panel? Are these early adopters versus later adopters? I can't actually.
It's the model versus the regulation.
Got it. Okay, very good. Obviously, the East Coast and Central US has done very well. Southeast, very strong. But we are making progress. So thank you for putting that up. New York and South Carolina are also recent adopters since our September meeting. We've had this on the agenda several times because it is important to uphold state-based insurance regulation. And this arises because under the terms of the covered agreements, the U.S. state regulators risk federal preemption of state reinsurance laws unless we have appropriate reinsurance collateral reforms adopted in the state law within 60 months of September 2017. So the 60-month milestone is out in front of us. That's at September of 2022. However, there is a separate 42-month deadline, at which point the federal government will begin conducting an assessment of any remaining non-compliant states. And so this will occur in February of the coming year. One implication of this, I think, is that as lawmakers, we will want to make sure that our clerks and our respective legislatures know if they were to get an inquiry from the federal government concerning the adoption of this statute, any lawmaker on the phone would want to make sure that they get that word from their clerk, or at least alert the clerk that it may come up. It may well be that the federal government may work with the NAIC, but I think we ought to have our clerks on notice that this is a topic they might hear about and we are following. So the question really for our NAIC partners, can we get an update as to how NAIC efforts have progressed in terms of working with state legislatures to introduce and adopt this legislation beyond those that we've already seen progress on? And so that is the first question, just an update from the NAIC on the implementation of this model act.
Mr.
Sure.
Chair, this is Glenn Mulready, and I will be covering that, but if we can, I might have our new president or incoming president make a few opening comments.
Sure.
Very good.
You beat me to it, Commissioner. Thank you for that. And Assemblyman Cooley, you can certainly have an update on how we're doing on the credit for reinsurance model law and model regulation, which, as Commissioner Mulready indicated, he'll provide that in just a moment. But before he does that, I did want to just take a quick second and thank you for the invitation to be here. As you indicated, I did humbly accept the step of becoming the president on January 1st of the NAIC, and I'm very much looking forward to that. I think I've been committed over the past several years as an officer, before that as a commissioner, and before that as a state insurance regulator, to ensuring that we continue to focus on protecting state-based insurance regulation. And I know that state legislative chambers around the country, as well as NCOIL, are also committed to that goal as well. And so I'm certainly looking forward to continuing to foster the collaborative relationship that NCOIL and the NAIC have had over the past several years. I don't see any of that changing. In fact, I see that improving in 2021, kicking off with this dialogue as well. I'd be remiss if I didn't also welcome those of you that are in Tampa to the Sunshine State. I'm sorry that I couldn't actually be with you in Tampa. I know it's been slightly chilly, but certainly if it's been anything like it has been in Tallahassee, we are living up to our nickname this week. And for those of you that weren't able to make it to Tampa, hopefully we have the opportunity to welcome you to our fair state at some point in the future. But Assemblyman Cooley, we are looking forward to the discussion today. But I just wanted, before we get started on that, just wanted to reiterate how excited I am for my new role and the discussions and the collaboration that the NAIC and NCOIL have before us in 2021, which, as you indicated, will be full of a lot of important issues. Yeah. And so with that, Commissioner, I'll turn it over to you to provide an update on the credit for reinsurance activities.
Okay, thank you very much. And Commissioner Altmeyer, I'm not sure if you noticed, but when Assemblyman Cooley mentioned you recently stepped into it in that role, I don't want you to read too much into that verbiage. We're excited for your leadership. And I might add too, before I touch on this, regards from my colleague Dean Cameron, Commissioner from Idaho. He's back in Idaho, and actually he's battling COVID himself personally. So I know he would appreciate your prayers. He's doing okay, but appreciate those prayers. So quick update on the credit for reinsurance models and where we are. As you saw from the map, we basically have at this point 16 states that have adopted, and then another 13 that are having that under consideration. We recently added New York to that. I won't rattle those off. I know many of those that have it under consideration, such as my state, the state of Oklahoma. We had it on the agenda, but due to a COVID COVID cut short session, it went by the wayside. So we expect this next legislative session to see a substantial improvement in action on many of those. There were 3 states that have adopted the model regulation, number 786, while 4 states, and I might mention those, the 3 states are California, Pennsylvania, and Virginia. They've adopted, while 4 states, Kansas, Mississippi, Vermont, and West Virginia, have action under consideration. We do anticipate, as I said, a number of additional states will take action this next legislative session. A lot of folks will have be playing catch up from things that did fall by the wayside last year. The 2019 revisions implement the reinsurance collateral provisions of the EU, US, and the UK, US covered agreements, which require states to eliminate the collateral requirements entirely within 5 years by September 1st of 2022, or be subject to federal preemption. The NAIC adopted the 2019 revisions as an accreditation standard with the effective date of September 1st of 2022, which coincides with the date when the Federal Insurance Office may begin preemption of state laws for any state that is not in compliance with the covered agreements. However, NAIC will not begin enforcement of this new accreditation standard until January 1st, 2023. So as was mentioned in the opening comments from Assemblyman Cooley, critically important for all legislators out there to get some movement on the credit for reinsurance models. So far, we've not had any specific conversations with either the FIO or the European Union about extending the deadline, but we have had some preliminary discussions with FIO on the status of state adoptions, keeping them up to date. Our best guess is that neither FIO nor the EU will agree to extend the deadline, and that states will need to adopt the revisions by September 1st, 2022, or face the federal preemption by FIO, which none of us wants to see happen. Continued state action on NAIC model is our best defense against further federal action. We appreciate NCOIL's support of these models. And then there's an updated, as you've seen here on the screen, updated NAIC legislative brief on the model should be in your materials, which includes the maps that's up on the screen now and showing state adoption and action. It's a quick update on the credit for reinsurance.
Very good.
The only thing I would add is Commissioner Mulready did an excellent job updating everyone on our progress there. The only thing that I would add is that this is a topic of discussion in our ranks as well. These are similar maps that we share with all of our members. All of our members, as Commissioner Mulready indicated, take very seriously our roles as state insurance regulators. And anytime the thought of preemption comes up, we take that very seriously. And so all of our members are actively working in their state chambers to pass this legislation. And so we feel pretty good about the progress that we're making. Obviously, 2020 was a little unique in some states in terms of the ability to work on legislation of this nature, but we're working hard on this. And as Commissioner Mulready said, appreciate the support of NCOIL on this.
Okay. Very good, Commissioners Mulready and Altmeyer. Kind of an open question on this general issue. Commissioner Mulready, you alluded to the fact that you probably do not anticipate a great deal of flexibility from the feds or the European partners if someone wanted an extension. That sort of gets to the issue of the ability of the NAIC and state lawmakers to work with the various administrations. This all got moving under the Obama administration, which had one relationship with the insurance industry and the NAIC. We have had your service during the Trump administration. We're going into the new administration. How do you kind of rate recent years, the ability to work with the feds? What are your hopes when you reflect upon, the last 6 or 8, and what sort of working relationship you look to in the future? Any thoughts on that?
I think Commissioner Altmeyer might have more to say on that, but that's a great question that's to be determined at this stage. And I know we as an organization are looking ahead to what to expect from the administration in lots of different areas, but our ability to work with them, I think, is solid. We've got a good cross section of parties and folks across our different states. And I'm sure as an organization, we will adapt to the new administration, but we really don't have any specifics on that.
Right. So I think Commissioner Mulready is right that we're anxiously watching the appointments that the new administration is making in some of the critical areas related to insurance. But I will say, during my tenure at least, I always look back to the 2008 Dodd-Frank reform. And when you look at how comprehensive that was and the fact that it essentially left intact state-based insurance regulation, we seem to have enjoyed, by way of our efforts over the past many decades and in collaboration with our state chambers, we have enjoyed, I think, the confidence of folks in the federal government that state-based insurance regulation works. And as we have liaised with our federal partners, that does not seem to have wavered. And so I think our priority will be continuing to work to ensure that whoever is in office in the federal government understands that this is something that we have done effectively for a very long time and that we can continue to do effectively in the future. And we'll certainly need the partnership of NCOIL and our state legislative chambers in order to continue to do that.
Yeah. Well, Commissioner Mulready, you alluded to that you moved to pull in this reinsurance requirement into the accreditation statute standards. Boy, early in my career, I was running the insurance committee in California in the late 1980s when the accreditation standard began to be adopted out of NAIC. Clearly, you've laid down a strong track record of closely monitoring the industry on its many fronts. It will be interesting just to see how things unfold as we watch the Biden administration populating its the administration.
Peterson's and Huntinger's bill.
Bob, you're not on mute. Just as we watch how they, who they put into these key positions. As a sidebar on that, we had a bill this year that our Attorney General was looking to expand that office's powers with respect to health insurance. I actually disagreed with it. And after a long conversation with my AG Becerra, the bill was laid aside. But I do think in the area of health generally, the litigation background he brings will probably be an asset to expanding coverage. So although I wasn't looking to expand his health portfolio as an Attorney General, I actually think he'll do a fine job in this new agency to kind of move things along that probably ought to be moved along. But that will be interesting to just see how he evolves in that role. But so I agree with you, Mr. Mulready, we will see how things unfold.
Assemblyman, since you just mentioned, I might just on a sidebar myself, our agency just went through the accreditation process and just last week in our fall national meeting received our 5-year reaccreditation. But just to comment on that, of course, for me, it was the first time going through that. And it's quite a robust process that our accreditation process does and making sure that each state is up to par on their financial oversight of their domestic. So having just personally experienced that and received approval with a few other states this past week, it's a great, robust process.
Very good. Were you going to make a comment, Mr. Altmaier?
Well, first of all, to congratulate Commissioner Mulready on that. I haven't had the chance to do so yet. That is a robust process and not always enjoyable. But I think the accreditation program has really been a testament to some of the things that I've previously said. And so we'll continue to work very hard on that.
Okay. I want to turn now at this moment to Senator Hackett, who has a question, then we'll go to George Kaiser. Senator Hackett?
Yeah, just a question is, hey, Ohio passed the credit for reinsurance this last week. So we concurred. All we need is the governor's signature, which he will do. So you can add Ohio to the list of states that accepted it. So that's great.
That is great, Bob. Thank you very much. George Kaiser?
Good morning, Mr. Chairman. Thank you. Commissioner Altmaier and any of the other commissioners on the call, I know that the statement, we make it, you make it, we make it, to retain state-based authority. But when you look at this, and this is about, gosh, I can give you about 5 other examples of the same format. It really is a variation on state-based authority. It's the federal government coming in and putting a gun to our head and saying, either you do something and create some uniformity on this issue, or we'll take it away from you. That isn't really state-based regulation as it was traditionally known, where we had incubators across different states doing different things. Are these reserving standards as appropriate for a small state like mine versus California? I'm not certain of that because I'm just not that knowledgeable. But my basic question is for the NAIC, at what point do we say we got to start limiting this blackmail by putting a gun to our head relative to state regulation and say, wait a second, we're doing a good job. There aren't the problems you're talking. And I know with this instance, there's international contracts and other things, but we're starting to lose very gradually state-based regulation with this approach. I'm just curious as to your response.
Well, thank you for raising that. You know, I think in the case of our credit for reinsurance models, I do think that while we followed a similar process at the NAIC to strive for some consistency here, as we have in past model laws and regulation that relate to the prudential oversights of our firms, I do think this one was a little bit unique in the fact that it did relate to the covered agreement, which had been done for the first time. And so we, I think, were a little miffed at the time that we weren't more involved with the drafting of the covered agreements and the negotiation of that and what ultimately was in the terms of the covered agreement. But unfortunately, once it was ratified by Congress, that was what we had to deal with. But I do think that the fact that we were able to retain, and albeit I will grant you that we were essentially told to do this, I think the fact that we were able to retain as state insurance regulators the ability to draft the model law, to work together to make sure the model law was reflective of strong state-based principles, I think was at least some advantage in that process. And we were able to still retain the ability to work with our state chambers in order to implement that. But certainly I do think the aspects of future covered agreements, if they could potentially come up, underscore the need for us to continue to stay in those communications and underscoring how effective we have been doing on issues of this nature. And so I do think this was a little bit of a unique circumstance. As you indicated, there were some international implications that led to the need for the covered agreement. And so that makes me feel slightly better that it wasn't necessarily drafted because of some shortcoming of the state-based system. And the fact that we were able to continue to work through our NAIC process to ensure that the model laws that ultimately implemented the covered agreement requirements were still drafted by state insurance.
I got to say something real quick.
Adopted by state chambers.
Very good, Commissioner Altmaier. And did someone want to jump in? I guess not. You know, George, it's an interesting problem. We have seen with the rise of technology, we see a greater interconnected globe. We've seen the formation of the European Union, which they're of course a part of this. You had the Basel Accords, which imposed privacy requirements, which were very uncomfortable for American businesses to learn to work with, and the need to kind of, there's been just a lot of dramatic things on the global scale that even as big as the US is, we've had to learn to interact with those partners. You know, this reinsurance agreements arises from this heightened level of global activity as the state steps up. I think it goes to the question of it becomes very important strategically to have a strong NAIC that is working on building relationships in DC. And we as state lawmakers can support that. We may from time to time want to have a sidebar with our regulator partners, but at the same time, I do think we have an interest in presenting a strong partnership to the feds so they feel like we are kind of working in tandem, working as one, and they can rely upon us in turn as strong partners to make sure that our regulators and state lawmakers have a seat at the table. There is that expression, if you don't have a seat at the table, you're on the menu sort of problem. And we want to have a seat at the table. So with no further questions at this moment, thank you for this very excellent discussion. And I do think we all have a lot to learn in the coming administration, and we have a stake in growing healthy working relationships to bring our expertise to bear on important questions of public policy. And I think you're right, George, to make sure that it is nuanced, so it does recognize the variation that exists across the 50 states, which at its core is the genius of McCarran-Ferguson. We don't want to lose that incrementally by neglect.
Well, Mr. Chairman, if I could add, beware of the camel's nose under the tent. This is not the first one. This is about the 5th time this has been done.
Yeah.
So it's time for us to have an honest discussion about this, because it is not state-based regulation. Yeah, they get to write it based on something that's dictated to them, but it's not what we have as state-based regulation. So I caution NCOIL on this. There will be more instances in the future, and we need to be ready to address them.
Yeah. Very good, George. I actually agree with that. To be a leader, you got to watch events, and you're saying pay attention to what's happening. So that is right. Turning to our next issue, when we met in September in Alexandria, we had a very robust discussion of the NAIC Statutory Accounting Principles Working Group in the effort to update the Statement on Statutory Accounting Principle number 71. This was the Policy Acquisition Costs and Commissions statement. For those that were not a part of that discussion, the proposed changes deal with something that is called commission funding agreements that some insurance companies enter into with third parties. And the issue is generally whether the arrangement should affect the commissions that insurers pay to their agents under statutory accounting principles by deferring recognition of that liability. We actually heard a mix of opinions as to whether the proposed changes of statutory accounting principle number 71 are substantive or non-substantive. And we had a discussion on if they are substantive, where's the authority for it? How does it get done? Is it done by incorporation, by reference, as is usually the case when legislature hear of substantive changes being made outside normal legislative process? We heard in Alexandria, as we're wrapping up, that the NAIC had heard from at least one commissioner raising concerns with the proposed changes and that they warranted further discussion. Earlier this week, CEO Tom Considine of the NCOIL sent a letter to the chair of the NAIC's working group with some expressing concerns with the proposed changes. What is the status on Statement of Statutory Accounting Principles number 71? And just what's new on that front?
Sure. Thank you, Assemblyman. So I'll start off on this one, and it sounds like you all have had enough discussions to be familiar with the background on this one. So I won't spend too much time on the background. You seem well versed on that front. So I'll skip right to the developments that have occurred recently. We did re-expose potential revisions to SAP 71 recently. The impact of that exposure, I think first and foremost, was to remove the effective date of SAP 71. It was originally intended to be at the end of the year, if I'm not mistaken. The current effective date of that now is to be determined. And we will continue to go through our robust and transparent process to continue the amendments to SAP 71. And once they are completed, then we will discuss the implementation date of that. So there will continue to be plenty of opportunities for our stakeholders to engage with that process on the revisions to SAP 71. The other development is that we have directed NEIC staff to develop an issues paper on this topic. The issues paper will essentially document and provide a historical reference of how the discussions have gone and how, and so looking back on this, we'll be able to see a historical record of how this played out and have some documentation to reference on that standpoint. We have had some discussion amongst ourselves, both at the working group as well as at the commissioner level, about the designation of these changes as non-substantive as opposed to substantive. The working group continues to feel strongly that these are non-substantive changes. The rationale behind that is that as we have explored this issue, we believe, the working group believes, that the changes, the amendments to SAP 71 are clarifying what we believed to already be the intent of SAP 71. And our processes, our guidelines, if you will, that is the characteristic that determines whether or not a change is substantive versus non-substantive. We have been told that some carriers might have a larger impact as a result of this change. We're aware of, I think, 4 carriers that are utilizing these types of agreements that would be impacted. The determination as to whether or not something is substantive versus non-substantive is not necessarily the impact to the balance sheets of the carriers, but whether or not it represents a substantive change from the intent of the accounting principle. And so that's why this one was designated as non-substantive, and the working group continues to believe that's the case. It's important to note, I think, that the designation of non-substantive versus substantive doesn't change the timing of the work that we're doing. We've been working on this one, I believe, since 2019. I think it's gone through multiple exposures. As I mentioned, it's currently in another exposure. And so even though it's designated as non-substantive, we'll still have plenty of opportunities for engagement and dialogue on this one. I feel like there was one other thing that I was going to add, but it's escaping me at the moment. So I believe that covers. We talked about the non-substantive designation. So in terms of the incorporation by reference, this will be consistent with how we've done other statutory accounting principles changes, in which we don't view these changes as changing public policy. We believe the public policy is already there, and this just represents an implementation of that. Was the other thing that I wanted to add there. I know there's been a lot of discussion both at NCOIL and at the NEIC on this issue, so I'll pause there. And if there are any questions, Assemblyman, I'm happy to respond to those.
Very good, Commissioner Altmeyer. Mr. President-elect, any questions on that end? Any colleagues want to raise a question?
Assemblyman Cooley.
Yes.
Yeah, this is Representative Carbaugh. I'm curious. So the idea is that we're clarifying what was original intent, is what you're saying. But is this not a solution for a problem that doesn't exist? It doesn't seem to be a problem I hear from constituents or regulators back in Indiana.
Well, thank you for the question, we do think what the instigating event of these revisions was the result of an examination that was conducted by a state on at least one carrier, perhaps all 4 of these. in which we discovered that there were these carriers that were not accounting for these agreements the way that we thought that they should. And so that would be the problem that we're attempting to solve for. And as a result of not accounting for these agreements the way that we thought that they should have been, we felt as if their financial statements were materially misrepresented. And so while that might not necessarily trickle down to a consumer level, I'm not sure that agents or consumers would necessarily notice that. It does speak to the ability for state insurance regulators to be able to review accurate financial statements of these carriers to ensure that we are protecting those consumers by not only ensuring the viability of the carriers that are insuring those individuals, but also ensuring the level playing fields of our markets. And so through that examination process, we discovered this issue. My understanding is that the states were engaged in discussions with those firms about correcting this issue, ran into some difficulties. And so the state regulators that discovered this through the examination process felt that clarifying the guidance here would be appropriate in order to prevent that from happening in the future.
Okay, has there been any thought given to a phase-in period? I know it sounds like you're delaying it, but what about a phase-in period so that the financial health of these companies can be taken into consideration?
Thanks for that question. We have discussed at a high level a phase-in period, but given the small number of companies that we believe have these agreements, we thought the more appropriate thing for those carriers to do, and we understand that they are already in the process of doing it, is engaging with their domestic regulators to work through perhaps a prescribed or permitted accounting practice that would allow that phase-in. It didn't seem to be appropriate to build in a phase-in period into the guidance because it didn't seem to be a large number of carriers that had these types of agreements. Since it was a small number, we thought that would be best left to the state insurance regulators, which do have the authority to work with these firms to find an appropriate phase-in period for the changes.
Okay. Is that responsive, Vice Chair Carbaugh?
Yeah, I appreciate that. I just want to make a comment that this seems pretty substantive and not a clarification at all.
Very good. You know, I do think,
Assemblyman Cooley?
yes. I don't see who that is, so. Oh, yes, Senator Holdman.
Yes, I'm sorry, my mic.
Trying to figure out the mic here.
Very good. You're good. I think you're on.
Here we go.
All that just to say a few simple words. I agree the explanation seemed to be treading on substantive matters, and incorporation by reference once again rears its ugly head. And I just think we need to be forewarned. This may come back to haunt us at some point in the future. So thank you.
I was going to offer the observation. I think the paper that is done, the background paper to explain how you construe that it fits within the original intent, it becomes very important. As a lawyer who's had a long practice in this field, you know, our statutes, we have to work with what are the words in the statute. That's where we get our intent. To take a proposal and just say there is a intent, which is itself kind of amorphous, and this fits with that intent, ergo it's not new. That's not actually the manner in which law is generally construed. Our statutes, where the regulator gets their authority. So it's actually not how state legislatures have to operate. We pass laws. The mere fact that someone was an author, frankly, is not definitive. Their view is not definitive on what the statute says. It's what are the words? How is it stated? How does it get construed in ordinary English usage? That's where the intent comes. But just in general, the idea that because in the past a group felt this was what they intended to cover, certainly does not cut it as a matter of law for what is the applicable law. And this is all about, you're talking to lawmakers. We are concerned about what is the state of the law in our various 50 states, and what is the nature of the requirements it imposes upon private sector in their conduct of their business. And we can always change the law, but it's not just done because someone thought, well, on balance, that's our intent, so it kind of fits, and so we're off to the races.
Well, thank you for all three of those comments. I appreciate them very much. So I'll just make a couple of words in response, and certainly happy to continue the discussion at your desire, Chair. Let me just go to the substantive versus non-substantive issue, and perhaps I should have provided a little bit more insight into how we made that determination and why we believe that this is consistent with the intent of the originally drafted accounting principles. And there's really two. There's statutory accounting principle number 5, which defines liabilities, and then of course statutory accounting principle number 71, which speaks to this relevant issue. Statutory accounting principles have been clear from the outset that policy acquisition costs have to be incurred by the carriers up front. And that's been a fixture of our accounting principles, as I mentioned, since they were drafted. And so that's been a long-standing issue. The reason this was flagged during the examinations is that when the state regulators saw these commission expenses, they were very clearly policy acquisition expenses that should be incurred by the carriers up front. And while some expenses from carriers can be contracted to third parties, policy acquisition expenses are not expenses that are able to be handled in that manner. And so the state insurance regulators at the time felt as if these agreements were working around the statutory accounting requirement for these to be booked up front. And so we believed that clarifying that was consistent with the original intent of the accounting principle, which is why we designated these non-substantive. Certainly, we've had our discussions as well about non-substantive versus substantive, and so I certainly respect the viewpoints of others that don't necessarily agree with that. With respect to the ultimate incorporation, every state does this a little bit different. And so, Florida adopts them by rule, for example. I know some do it via statute, and I'm sure there's other mechanisms around the country for how these are ultimately adopted. I'll have to take these changes to our cabinet. They probably won't look at them specifically, but we will go and acknowledge that we're updating our technical accounting guidance. I think that if we were to ever make any kind of move away from statutory accounting, what I don't envision, certainly we would view that as substantive, that we would want to come and say this is probably a policy shift versus just implementing already existing policy. But for now, I think as we've discussed this, I think we remain of the opinion that this isn't necessarily a change in policy. This is just implementing the technical aspects of already existing policy. And so I'll just kind of pause there. That's sort of a little bit more of a deep dive into our rationale for continuing to designate this as non-substantive, but I'm hopeful that the removal of the effective date, there's no longer a looming effective date. I'm also hopeful that the issues paper will help to clarify a lot of that and set the stage for some additional discussion going forward.
Very good.
Assemblyman Cooley.
Yes, Martin Carbaugh.
Yeah, sorry about that. I just, something in that, talking about acquisition costs need to be accounted for all up front, and saying, so I want to make sure I understand this. So if a commission is scheduled at 1% a year for 6 years, that's 6%. And so what you're saying is all 6% should be accounted in year 1. Is that correct?
That's my high level understanding. It won't take us long for me to get to a point where I'd have to refer back to some of my more technical experts. But one of the key principles of statutory accounting, and one of the reasons why it was important for us to have this system of accounting versus something like GAAP is that we wanted to make sure it had a little bit more conservatism built into it than GAAP in recognition that when an insurance company sells a product, they aren't certain how much that product is ultimately going to cost them. And so our accounting framework should be reflective of that. And it should give state insurance regulators the ability to quickly identify carriers that may run into financial concerns. And so one of the principles we established consistent with that conservatism principle is the principle that things like those types of expenses should be recognized up front as opposed to earned out, to give state insurance regulators the ability to ascertain how much premium dollars need to be earned, and if those start to level off, if that becomes a financial issue for the carrier.
Very good, Commissioner Altmeyer. Mr. Carbar, did you have a follow-up, Representative Carbar?
Well, I guess kind of. I don't follow the logic of it, because if that's the case, where 1% per year, you got to account for it in year 6. If the contract moves in year 3 and they move the money to another annuity somewhere else with another company, they never paid the other 3% that they're now saying they've got to account for all the way up in year 1. Do they get a credit back? And I guess the other thing, just more generally, after 20 years of this, why now?
So to respond to a couple of those things, I think I'll do the second one first. Actually, I think the why now is because a group. First of all, not many carriers are doing this. We're aware of 4, and so it wasn't something that became readily apparent to insurance regulators that was even occurring until a group of carriers went through their examination process. And so I think that's the reason why it's come up now, is because of a difficulty from at least one state, if not a handful of states, in addressing this issue through the examination process. To the first question, I think that's a little bit more dependent upon the relationship that carriers have with their agents in terms of what they have determined with respect to their commission payments. My understanding with these particular agreements in question is that the third party pays to the agent the commissions up front, the entire lump sum of it. And then it's the insurance company that reimburses the third party over a period of time. And so depending upon the specific wording of those contracts, if the insured was to move to a different carrier, the third party has still paid the full commission to the agent. And as far as I know, the insurance carrier is still obligated to reimburse that third party for the full amount. And so I think that's one of the things that kind of complicates attempting to answer that question a little bit, is that dynamic that's at play there.
Okay.
So doesn't this ultimately kind of push companies more just to pay it all up front if they've got to account for it all up front, and kind of get rid of the ongoing commission? And if that's the case, that's a real 180-degree turn from the securities industry that's really pushing everything away from commission up front and into the fee-based ongoing earn the business every year kind of a mentality, which I think is better for consumers too.
Well, appreciate that, and happy to explore that with you further. My gut reaction to that question is that I probably not, and the reason why I would suspect that is again, the majority. My understanding is that the majority of carriers in the marketplace are not utilizing these types of agreements, and so they continue to have the same commission structure that they've always had, the accounting treatment that it's always had. And so I would suspect that given the fact that not very many carriers utilize these types of agreements, ultimately these changes to SAP 71 shouldn't have a material impact on the majority of the marketplace.
Okay.
But as I mentioned, happy to explore that thought with you further.
I want to thank Commissioner Altmeyer for this conversation. I thank all my colleagues for jumping in. We actually do want to, again, congratulate you on your leadership responsibilities in the year ahead. Obviously, this topic is a matter of interest to lawmakers, and it sort of puts a spotlight on this general issue of what is the basis of law and regulation in the insurance industry and the intertwined nature of statutory adoptions and regulatory adoptions, and that at the end of the day, each state regulator derives their authority from their own state statutes. There is no other source of authority. And as much as the NAIC has grown in its size and significance, and in my career, I go back to the years when you actually had real quarterly meetings all around the country, and I traveled to many of those. Still, its authority is strictly a derived authority from state law. And so we must be partners. So again, I think the change in the implementation date to be determined is a good one. That leaves the conversation clearly a little more open-ended. And the background work to kind of explain the thinking, I think, is a part of what you had noted, a transparent process to expose the thinking that undergirds the action. So with that, I want to turn to item 4 in the agenda, which is the NAIC's special committee on race and insurance underwriting. We held its first meeting on Wednesday. A very productive discussion on the background on insurance industry ratings regulation. A definition of proxy discrimination was discussed, and the examination and consideration of a wide array of insurance rating factors. We were certainly benefited from former NCOIL President Senator Breslin's chairing of the committee and that dialogue, as along with that of current NCOIL President Representative Lehman. Great job of facilitation, so thank you to them for their work. I want to pause for a moment and ask Mr. Considine if you want to offer some comments on this topic.
Thanks, Mr. Chairman. I'm actually going to defer to President Lehman, but since you did call on me, I would like to just touch very briefly on incorporation by reference and say to Commissioner Altmaier that we hold out Florida as just a gold standard on how it should be done, that if every state operated the way Florida did, I think certainly NCOIL as an institution and the member legislators of NCOIL, almost without exception, wouldn't have an issue with it. The fact that you take the items that are incorporated by reference but go through the official regulatory process, it is just really what we consider to be the gold standard among the states. So thanks for that.
Very good, Tom. Thank you for that comment. So I'm actually going to invite Mr. President, Representative Lehman, if you would like to offer a comment on this item, agenda item number 4, the Special Committee on Race and Insurance.
Sure. Thank you, Mr. Chairman. As you know, NEIC began this process. NCOIL joined in. I thought we had a very productive meeting. Yesterday, we had over a dozen presenters with volumes of data. I thought we stayed on track with what we were after, which was to be very data-driven and actuarial-driven. I want to thank Senator Breslin again for navigating through that. All the committee members who participated asked good questions. We'll process through all this, and then based on the data that we come up with, we'll set a course of action. I'm looking forward to continuing the work with President Altmaier. I must say that when Ray Farmer and I started our tenures as presidents of these organizations together a year ago, we said, hey, we're looking forward to a great year. Never did I think we would have as much communication as we had over the last year on multiple issues, and Commissioner Farmer did a fantastic job and really helped me a lot. And so when I know he's not on the call, but I really want to give a shout out to him, and really looking forward to President Altmaier working with you through some of these issues. And it's going to be interesting to see where this goes. As again, I think yesterday we saw a lot of actuarial data that we're going to be working through, and appreciate what NEIC is doing. And we'll continue to be a partner in this.
Very good. Thank you, Mr. President. So as Matt just mentioned, NAIC has its own special committee on race and insurance, and you've convened a number of meetings so far. So maybe we can get an update on what's gone on so far, how the committee is put together, how it's structured, what some of its goals are evolving to be.
Sure, and thank you for that. And before I get too far into that, President Lehman, thank you for those comments about Director Farmer. I'll make certain that I pass those along to him, and I would be surprised if he did not echo the same sentiments. And so I'll be sure to mention that to him. And also I was talking with Commissioner Mulready yesterday, who mentions your meeting on race and insurance and spending all day in that. So had a little bit of an update on that. And so looking forward to how both of these work streams proceed into 2021. But in terms of the NAIC's work stream, we kicked this off in the summer. And I think we are all in a similar posture as President Lehman seemed to indicate. We also at the beginning of this year did not expecting to be having some of the conversations we were having over the summer. But as Director Farmer likes to say, that was the year that we had. But we do have a special committee on race and insurance. These are the kinds of things that we just invite any commissioner who would like to participate to participate. Most of our task forces at the executive level, you can expect somewhere between 15 and 20 commissioners to join up. This one, we're up to 53. So 53 of our 56 jurisdictions have become members of this, which I think underscores the importance that our membership has placed on this issue. It's currently co-chaired by Director Farmer and myself, and the co-vice chairs are Director Dean Cameron from Idaho and Secretary Treasurer Clora Lindley Myers from Missouri. So it's no accident that the two co-vice chairs are our other two NAIC officers. It's great to have 53 members of the committee, but I'm sure as all of you can relate to, oftentimes that makes it a little bit more challenging to get meaningful work done when you have such a large number of people. So we broke things up into 5 work streams. We've got 5 work streams. The first 2 are focused on researching and analyzing the level of diversity and inclusion within the insurance industry. That's work stream number 1. And then work stream number 2 is the same effort, except focusing on the NAIC and state insurance regulatory community. The 3rd, 4th, and 5th work streams look at what barriers might exist in the insurance sector that potentially disadvantage people of color and historically underrepresented groups within the property casualty industry, which is work stream 3, the life insurance and annuity industry, which is work stream 4, and the health insurance industry, which is work stream 5. The work streams have all been working very hard during the summer. The full committee has had 2 public meetings. The most recent one was earlier this week at our fall national meeting. At that meeting, the committee heard updates from our 5 work streams. As I mentioned, they've reported some of the work that they've been working on. We anticipate the work streams providing initial reports by the end of the year that includes their findings and what would be initial recommendations to the full committee. And I believe these recommendations will not necessarily be, they'll be more like recommendations of things that we can further explore in 2021. So I would anticipate that these will be recommended areas that our existing committee structure can focus on in order to continue this good work into the year and perhaps creating new work streams as that continues to go forward. Internally at the NAIC, they're demonstrating their commitment to lead by example in this area. We've just hired a director of inclusion and formed an employee-based council on this issue that will be working with NAIC management and our members on driving some of these cultural transformation efforts. I think we're all very encouraged by the discussions that are taking place all over the place on this, both at the NAIC and NCOIL and everywhere else. We're looking forward to the efforts. We're looking forward to being collaborative. And I know this will be a topic that we continue to discuss in 2021.
Okay, Commissioner Altmeyer. Now my recollection is that at least in the past, working within the committee structure, that at the start of each year, the committee would sort of identify its working goals for a given committee. That's kind of a dated perception, but that is my recollection. That was generally something that came up early in the year. So is it the thought that some of these topics may feed into that sort of priority setting for the various committees of the NAIC? Is that what you were describing?
I would expect so. Yeah, yes, sir. And I think if 2020 has taught us anything at the NEIC, it's that you've got to be ready to pivot your priorities. And certainly our priorities at the end of this year are much different than they were at the beginning of this year, in the sense that our plate has gotten fuller. We did specifically note when we were adopting our charges for the upcoming year for our letter committees, we did specifically note that we haven't changed the charges for the Special Committee on Race and Insurance, but we anticipate revisiting those charges and revisiting the charges of our letter committees, reflective of the work that the Special Committee does as they generate their reports. And when we go through that process of updating our charges, it's very transparent. Those charges always get exposed to our stakeholders, so everybody will be apprised of those changes as they occur.
Okay. And the timing for the identification of the early findings is anticipated to be what?
We're hopeful by the end of the year, the work streams will report those findings to the special committee. And then I would envision the special committee having a discussion about how to best go about exploring those recommendations, whether it be assignments to our existing committee structure, perhaps having some of the work streams work on them themselves, or whatever the most effective way might be there. But we're hoping to have those initial recommendations by the end of the year.
So that's the end of, in the next couple of weeks then.
Right. And we've already been flexible with that. I think we had hopes to have some things by the fall national meeting, which was over the past couple of weeks. But as the work streams started to have their discussions, there was a sense that we might need at least a few more weeks on that. So that's why we're targeting the end of the year. But I think we're certainly wanting to put the quality over the work, over the timing to get it done. So if we get to the end of the year and we need to have a few more conversations, I'm sure we'll accommodate that.
Now, and as a committee meeting, is that a convening a Zoom type of meeting? Is it a public meeting if someone wished to participate or at least listen in?
When we get to the point of documenting our recommendations and determining what our next steps are going to be, my anticipation will be that will have some transparency. It will most likely be virtual, especially if it's at the end of this year or in the first quarter. And we have had a couple of public meetings already in which we've had stakeholders join the Zoom calls, and I would anticipate arranging that again for this one.
Very good. Thank you, Commissioner. Any follow-up questions from any members on the call? Okay, well, I thank you for that update. And again, thank you for Ray Farmer's leadership, your own leadership, moving this conversation forward. And again, Neil Breslin and Matt Lehman, thank you for an excellent program on Wednesday and moving this conversation along. The next item on the agenda is the discussion of the market conduct annual statement blanks. For those unfamiliar with the term of market conduct annual statement, the goal of the MCAS project is to provide a uniform system of collecting market-related information to help states monitor market conduct of companies. A big idea in the MCAS setting has been the development of a more transactional level reporting of data for travel insurance, as opposed to the historically used summary reporting approach. This idea came out of the Center for Economic Justice, Bernie, who I've known for many years. But the more granular reporting is a change. It constitutes a change of reporting burden on carriers and is notable as a change. Can you walk us through the status of that conversation and report on the working group's initiatives? Someone?
Yes,
Yeah, I
thank
think-
you, Assemblyman Glenn Mulready here.
Very good.
I'll touch on that, and you did a great job of introducing that. And just to give a little detail to that, the market conduct information that is gathered is typically things that our state analysts wouldn't be able to obtain on a financial annual statement or some other source. Things like policy renewals, surrenders, replacements, cancellations, claims payment and denials, those sort of things, and also complaints and lawsuits. This year, the Market Conduct Annual Statement Blanks Working Group is focused on travel insurance and other health products such as short-term limited duration. They're drafting those blanks for those as we speak. The process of creating a blank is a collaborative effort which involves regulators, industry, and consumer representatives. As you mentioned, that's not a new request, but for a few years now, the consumer representatives have been pushing for the collection on a transactional basis, and you touched on that. During the drafting of the short-term limited duration blank, one of the consumer reps suggested that we consider piloting that with that short-term limited duration as a transactional level market conduct annual statement. The short-term limited duration drafting group raised the discussion to the blanks working group, which considered the suggestion during its September meeting. During its October meeting, the working group heard a presentation from NEIC IT staff concerning the resources, the time, and effort needed to collect that on a transactional basis. And you as well alluded to that in your introduction. After discussion in its November meeting, the Market Conduct Annual Statement Blanks Working Group decided against pursuing a transactional pilot for this. Their decision was reported to the Market Regulation and Consumer Affairs Committee during the fall national meeting. They have left it open, though, for further discussion or conversation down the road or at a later date. I'm not sure how much energy personally is really behind that, but they did leave that open. The D Committee adopted the working group report and agreed with the decision not to proceed with the collection of transactional data in the Market Conduct Annual Statement Blanks Working Group. Quick summary of the update.
Okay, very good. Thank you, Commissioner Mulready. Anyone else have a follow-up question? So it's sort of an explanation of, I often say of legislation, laws are ideas that acquire a following, and not every idea actually gets a head of steam behind it. So it sounds like you had internal discussions, weighed it, looked at its resource implications, pros and cons, on some generic level, the gains to be had versus the attendant cost of implementing it, people and resource wise, and have sort of set that idea for a time. Although, as you note, it's, you can't unring the bell. The conversation's been held. At some point, it might stir itself again. Any questions on that from my colleagues? Okay, well, with that, again, President-elect Altmaier, we are delighted that you were able to join us. And you started your comment saying it wasn't 100% sunshiny there where you were at, and maybe not in Tampa. So you never want to say that. It just totally destroyed my vision of what I was missing.
Well, to clarify, it's been very, very sunny. It just, not all of the warmth from the sun has quite made it down. It's been a little on the chilly side, and Commissioner Mulready was quick to point that out to me yesterday when he and I were talking, was that it was a little colder than he was expecting. But I understand it's warmed up a bit. I hope that it's very sunny, and I hope that you all get the opportunity to enjoy our state, those of you that are there. Assemblyman, I just want to thank you again for the opportunity. I know that NCOIL and NEIC have been working over the past several years to really foster an effective working relationship for our common goal. And I just want you to know and your members to know that I'm committed to continuing that in 2021. I hope this was a good start this morning, and I hope that we have many more fruitful discussions of this nature going forward. And I'm hopeful that very soon we can actually all sit in the same room and do those together. So thank you again for having me.
Very good. Well, delighted to have you. And when you tell me it's a little cooler than normal in Florida, I just think that probably means that when Tom Constantine goes out, he has ankle socks on his flip-flops to warm him up a little bit. And that's probably a scary image to have anyway. All right. Well, if there's no further business, may I have a motion to adjourn?
So moved.
Moved by Mr. Carbaugh, and a second.
Second.
All those in favor, please say aye.
Aye.
Aye. Well, I thank you very much. Thank you for this session. And we move on now to the next item on the program, which I believe is lunch. All right. Thank you very much.
All right. We'll get this general session going here. A few minutes late to give people time to get on Zoom and here in person. Good afternoon, and thank you for joining us. Rep. Joe Fisher was going to do this, and I was asked to pinch hit here yesterday as he had a meeting to get to. My name's Martin Carbaugh. I'm a state representative from Indiana, and I'll be moderating this general session. We have a great and very distinguished pair of speakers with us here today to discuss a very important and interesting topic, the current state of the U.S. healthcare system, particularly the future of the Affordable Care Act, ACA, in light of the pending litigation and recent elections. As we all know, the ACA has been a lightning rod for debate since President Obama signed it into law in 2010. Since that time, the debate over the ACA's effectiveness and constitutionality has not stopped and has seemingly grown more fierce with each passing year. I know the annual debate on these key issues at Will's Thanksgiving dinner a couple of weeks ago was certainly not lacking in energy, he tells me. Just last month, the Supreme Court of the United States heard oral arguments on California versus Texas, known as Texas versus U.S. in the lower courts. I'll let the speakers discuss the litigation in much more detail, but the litigation centers around the constitutionality of the ACA in light of the individual mandate penalty being reduced to 0 in 2017. Regardless of the Supreme Court's ruling, its impact on the future of the healthcare system will be monumental. As if that was not enough to talk about, we just had an unprecedented election season, which technically isn't finished due to the Georgia Senate runoff elections. Regardless of who comes out on top of that runoff, reforms to healthcare system are almost certain. This session will therefore be a great opportunity for dialogue centered around the current state of the U.S. healthcare system and what the future holds. Joining us today to discuss these issues are Abby Gluck, Professor of Law and Faculty Director of the Solomon Center for Health Law and Policy at Yale Law School, Professor of Internal Medicine at Yale Medical School, and Chris Pope, PhD, Senior Fellow at the Manhattan Institute. And if you get a minute to check out the app to take a look at their resumes, it's quite impressive. And because of some scheduling, we're going to hear from Professor Gluck and take questions for her, and then she has to jump off the Zoom. And after that, we'll go to Chris. So with that, Abby, we look forward to hearing your remarks.
Thank you so much, Representative Martin. Are you able to hear me okay? My audio has been having some difficulties today.
We can hear you in Tampa real well.
All right, great. I wish I was down there with you. I want to extend my thanks to Will for organizing the panel, and to Will and Chris for being so gracious about accommodating personal emergency. I have a funeral I have to attend, and so I'm sorry that I can't be here with you longer. So what I thought I would do was just talk a little bit about what's happening in the courts with respect to the Affordable Care Act, and then take some questions, and then leave it to Chris to really talk to you about the various policy implications of the election, although I'm happy to take some questions on that. One thing I want to say at the outset is that I know issues related to the opioid litigation are also of incredible importance to this particular body. I am very versed in that litigation, and I'm happy to take any questions on that in the Q&A. I do view that as part of sort of the package of healthcare litigation that we're dealing with going into this year. We're dealing with sort of the ACA stuff, and we're dealing with at the same time the opioid litigation. I'm going to switch my screen just one moment because I'm having some issues with my visual, and it will help me to see you all. So thank you. So what I want to talk about now is the Affordable Care Act and what's happening in the court. So as most of you know, no doubt, the Affordable Care Act is the most challenged statute in modern American history, and maybe in all history. There are 7 cases that have been at the Supreme Court already, and an 8th case has recently been granted certiorari. So that means granted review. So that means the court will have heard 8 cases involving the Affordable Care Act in as many years, 8 years. There are also 1,100 cases pending in the lower courts, challenging the statute or challenging the implementation of the statute in one way or another. So I'm going to briefly highlight for you what's happening in the Supreme Court and then give you a window into some of the more high-profile challenges that are pending in the lower courts, and then take some questions. So what's happening in the Supreme Court? Most of you are, as Representative mentioned, are well aware of California versus Texas. For those who aren't, let me quickly summarize what that case is about. That case goes back to the day the Affordable Care Act was signed on March 23rd, 2010. A number of states brought a challenge to the individual insurance purchase mandate, contending it was unconstitutional. Remember the famous "Can Congress make you eat your broccoli" argument. That went up to the Supreme Court, as you all will recall, in 2012. In NFIB versus Sebelius, the Supreme Court upheld the Affordable Care Act, as you know, and made the Medicaid expansion optional. But specifically with respect to the insurance purchase mandate, Chief Justice Roberts provided the deciding vote and said, well, while Congress could not use its commerce power, its power to regulate interstate commerce, to require Americans to buy health insurance, it could use its tax power because the mandate was enforced with a tax penalty. Fast forward many years and many efforts to repeal the Affordable Care Act. In 2017, after Congress failed to completely repeal the Affordable Care Act, at the end of the year, as part of the Tax Cuts and Jobs bill, Congress did make one important amendment. It zeroed out that tax penalty from $695 to 0. And people always ask, why didn't Congress just repeal the whole Affordable Care Act? And that goes to a question of congressional procedure that I'm happy to talk to you about if at all interested. But it happens to be the case that for budget bills, Congress only needs 51 votes, as opposed to substantive legislation, the Senate needs 60 votes, thanks to the filibuster requirement. At the time, due to the voting majorities in Congress, there were not 60 votes to repeal the whole Affordable Care Act in the Senate, or even to repeal the entire insurance purchase mandate. But there were 51 votes to just reduce that penalty to 0. That's how we got where we are. A few months later, at the time 20 states, but now only 18 state attorneys general, brought a case in district court, federal district court in Texas, saying this insurance purchase requirement is no longer constitutional. The Supreme Court said it was a tax. The tax is now 0. A tax without 0 isn't a tax, so it's no longer a valid tax, and it's unconstitutional. We can talk about that. There are arguments on both sides legally about why it's a tax or why it's not a tax. I think most people, maybe you disagree, most people in the healthcare space think this is a relatively unimportant question at this time. The mandate had been under-enforced, and the markets had mostly absorbed the impact of a mandateless ACA. The reason the case is significant in the Supreme Court is that the litigants went further and said, well, we think the mandate is unconstitutional, but we also think the entire Affordable Care Act is pinned to the mandate, can't function without it, and so the whole thing should be struck down. And that's why the case, now called California versus Texas, has gotten so much attention. So let me just briefly tell you about the Supreme Court argument, and I'll move on to the work requirements. So as you may have read in the newspapers, the Supreme Court was not, if you can read the tea leaves of the Supreme Court, which is always difficult, there do not seem to be votes on the court to strike down the entire Affordable Care Act. Chief Justice Roberts and Brett Kavanaugh were both very skeptical of the litigants' arguments, in part because the legal test they have developed is a test called severability. It asks the court if it should just sever, cut out the one offensive provision or strike down the entire law or a part of it. And the legal test the court has developed is all about what Congress said, what Congress intended. And the Chief Justice and Justice Kavanaugh had a very hard time finding evidence that the 2017 Congress was actually striking the entire Affordable Care Act down. And in fact, the Congress took out the mandate penalty and left the rest of it standing. And as the Chief Justice said in oral argument, maybe some members wish for the thing to go. They were hoping we'd strike it down. But in his words, he said, that's not our role. That's Congress's role. So with that, it seems that the entire Affordable Care Act is likely to be safe. There was not a lot of pushback on these points from even the other conservative justices on the Supreme Court. I do think there's a possibility that the individual mandate is going to be struck off the books. There was much more back and forth on the court about whether an insurance purchase requirement that is not enforced by a tax can be on the books, whether there are other congressional powers to support it, or whether it could still be construed as a tax. So I don't think it's unlikely that we're going to see an opinion that says the individual mandate is gone, the rest of the Affordable Care Act stays. So that's where California versus Texas is. And we'll hear the results of that case by June of this year, when the court of 2021, when the court's term ends. The other case that's pending in the Supreme Court involves the Medicaid work requirements. As many of you may know, a bunch of states have requested waivers for the Medicaid program to allow a work requirement before allowing individuals to enroll in Medicaid. The DC Circuit, the Federal Court of Appeals in Washington, DC, issued a very important opinion authored by a conservative judge, which made it all the more or less political and more salient, in which they held that the HHS had not justified that the program satisfied the objectives of Medicaid. This case had been pending, and I think most court watchers thought that we were going to wait for a Biden administration to determine what was going to happen to this waiver program. I think the court surprised some people last week when it reached down and granted review relatively quickly. And so it's now possible that we're going to hear the Supreme Court's position on the validity of the Trump administration's work requirement waivers, even as the Biden administration is considering what to do with them or whether to change its waiver rules. So that's going to be sort of logistically interesting and challenging. And that case will be able to go forward, likely, even if the Biden administration changes sides, just because the states have a vested interest. Let me say a few things about some other pending cases. The other big cases that are floating around that may be of interest to some of you involve the so-called public charge rule. This is the Trump administration rule that effectively penalizes immigrants on their score for their immigration to the extent they use public services, including healthcare services. That rule has been challenged in several courts, and now there are different courts across the nation that have produced different rulings on the validity of that rule. That is another one of those rules that one would expect the Biden administration potentially to revisit. And there's always a tricky question about what's going to happen to these cases if those rules get changed. In addition, the Affordable Care Act has another rule, it's discrimination rule, section 1557, which you may know has been the cause of a lot of litigation ever since the Obama administration. That litigation continues, and it centers around the discrimination based on sex provision of that statute. The different administrations have taken different positions on whether that word sex covers sexual orientation and access to reproductive services like abortion. As you also may recall, last spring, the Supreme Court decided a very important civil rights opinion called Bostock that interpreted Title VII of the Civil Rights Act, in which the Supreme Court held that the word sex in the Civil Rights Act of 1964 includes sexual orientation. So there is now a debate in the lower courts about whether the Trump administration's interpretation, which did not include sexual orientation as a grounds for non-discrimination, is invalid in light of that pre-existing Supreme Court case, which, by the way, was authored by Neil Gorsuch, one of the court's conservatives. I mention this, I keep mentioning who's authoring the opinions and where people are, because I think it's really important that while the Affordable Care Act has been so politicized over time, there are some pieces of this that are not politicized, and that's important. Now, there's a whole bunch of other cases pending that I think are probably of special interest to this group, this population. These are a bunch of cases that have to do with alternatives to the Affordable Care Act. the short-term limited duration health plans, the association health plans, broad constructions of ERISA to determine who is an employee, who is not. There are a series of cases in the lower courts that are grappling with the Trump administration's interpretation of the Affordable Care Act to allow those kinds of plans. And a lot of that obviously rests in your court, rests with you in terms of what plans you're going to approve. And I think going forward, there's going to be some urging on the part of local insurance officials and legislators to really try to resist, and I should say healthcare ministries also fall in that bucket, to really try to resist these alternatives to the Affordable Care Act that seek to move healthier, younger people outside of the insurance pool and give them less comprehensive coverage in exchange for lower costs. I understand this is a big policy debate in these circles. I'm sure Chris has a different view, which he'll probably talk about when I leave. But just if I'm sitting here sort of forecasting for you, what are the legal issues you want to pay attention to? I think you want to pay attention to a world without a mandate, a world where we're grappling over what the Affordable Care Act prevents in terms of insurance discrimination. And I think you want to focus on a world in which we're grappling with what kinds of plans in terms of alternatives to the basic ACA insurance pool are going to be approved of, validated, upheld, or struck down in court. There was a big case that came out of Texas a couple of weeks ago about a company called Data Management from the district court in Texas, where a company that paid people to use, an internet company that paid people to use their personal data, treated those people as employees for purposes of ERISA and pulled them out of the Affordable Care Act pool, right? Even the Trump administration's Department of Labor even opposed that interpretation. The lower court in Texas upheld it and said this exemption was okay, right? So that's going to go up to the Fifth Circuit. We'll see how that goes, but it's a really good example of the kinds of arguably very broad and probably inappropriate interpretations of existing law as an excuse to pull people out of those insurance markets. The other thing I think I would just say to you guys in terms of your role and what to expect is I think you're going to expect in the new administration a lot of regulatory action around all the things I've talked about. All of these different aspects have been regulated by the Trump administration. The new administration is going to have to review these things. They're going to have to review waiver guidelines, both for Medicaid and for ACA 1332, which is the main waiver provision, which allows states to come in and say, we want to do our Obamacare markets differently. We want to sort of opt out of the basic structure and do something new. I think we're going to see a second look at a bunch of those from the Biden administration. And I want to mention two other things. Telehealth, although it seems sort of not relevant to this conversation, when I think about the kinds of things that local insurance regulators and representatives are going to have to be thinking about going forward and where we are, I think about this bucket of ACA things. I think about the opioid litigation and the large amount of money that's going to be coming into the states in the next 12 months and how the states are going to have to deal and figure out how to distribute that money. That's very complicated. I'm happy to talk about that. I spend a lot of time on that in my day-to-day life. And then I'm thinking about a couple other things. I know Chris has written quite a bit about the situation of the elderly and long-term care. He's diagnosed what we all realize is sort of a very difficult situation right now with how we're regulating the elderly and congregate living. I think he and I probably have different views about what needs to be done to help that elderly, but the idea that that is an area of focus, that has to be a focus going forward, I think is undeniable. And then finally, telemedicine. You know, as you know, the pandemic has shifted the inertia that long surrounded the ability for states, for practitioners to engage in telehealth services from their computers, services across states, services by phone. The federal government enacted some temporary changes to the Medicare and Medicaid program. And many of you also enacted state laws, executive orders, and so on that allowed for telemedicine to proceed and, most importantly, for insurers to be paid for those services during the pandemic. I am the chair of the Uniform Law Commission's Healthcare Monitoring Committee. And one of the things that I've been focusing on for about 5 years is telemedicine. Is there a way to get insurance payment parity? Can we pay insurers? Should we pay insurers for services. Should we encourage insurers to pay providers for services that are not provided in person? And I can tell you that there's been very little interest in that topic or little movement until the pandemic. And the pandemic has moved the needle. So I do think that is going to be a very big issue. And one that I'm going to be working on personally, that I hope, if any of you are working on or particularly interested in it, I hope you'll reach out to me. I'm very easily findable on the Yale Law School website. I would love to hear your views on that. I think that I want to make sure there's time for Chris and a couple time for questions. So I think I'm going to stop there and just see if anybody has any questions about what I've talked about before I jump off.
Well, thank you, Professor, for those remarks and giving us a big overview here. I wanted to mention something here. You mentioned dealing with regulation changes. The Trump administration, presumably, am I right in assuming that they've really interpreted things to provide more options outside of the traditional health insurance space? And so am I hearing you saying that some of the new options that people have taken may be rolled back or taken away with the new Biden administration?
Yeah, I think that how I would characterize those new options, it depends. So I think with the Trump administration, there have been a couple of very significant moments of regulation. They have dramatically curtailed funds for people called insurance navigators to help encourage people to get into the Obamacare regulatory insurance system. The Obama administration had much more money devoted to those positions. I would not be surprised if the Biden administration put more effort into enrollment. There's also been high-profile lawsuits already based on the short-term limited duration healthcare plans and the association healthcare plans and the healthcare ministry and that ERISA exemption that I just mentioned. In each of those areas, with the exception of the Texas case involving ERISA, the Trump administration has encouraged, but through its interpretive reading of the Affordable Care Act's text, broader interpretations of the exceptions. So as one example, short-term limited duration healthcare plans used to be limited to 3 months. And the Trump administration has allowed those to go on for 12 months and actually be renewed up to 3 years. That's a very big difference. 3-year temporary stopgap insurance versus, a 3-month temporary stopgap insurance versus a 3-year change, pulling someone out of the market for a very long period of time. So yes, those are the kinds of things that have both been litigated, but began with regulatory action by the Trump administration, changing some of the positions of the Obama administration. And one would expect in any presidential administration that there's going to be review of existing regulations and there's going to be changes to those regulations. And given that these have already been the subject of high-profile litigation, I think most people would assume that there's going to be a second look given at a lot of these options.
Okay, thank you. Representative Lehman.
Thank you, Mr. Chairman. Thank you, Professor, for being here, and they're gonna get here eventually. There we go.
There we go. Thank you.
The question I have is kind of another rail in all this, and that is this week, I think it was yesterday, the day before, the Supreme Court ruled unanimously in favor of the Arkansas law on regulating PBMs. And that became an issue in a broader sense. Is that kind of a one-time deal or one-off, or is this going to be now more of with this court, more of an issue with undoing a lot of the ERISA protections that were put in there in 1974?
Yeah, I pulled the opinion because I've been dealing with these passings of two friends in my life over the last 2 days. I haven't read that case yet, but I have pulled it. It's really fascinating to see the Supreme Court weighing in on that issue. PBMs have kind of operated under the radar for a lot of people for a long time. I don't think that this is writing on the wall for the Supreme Court to be trying to undo. I don't see any evidence of that. I would want to reread the opinion for myself, but I haven't seen any evidence of that. That's sort of the beginning of the end of ERISA. I don't think the Supreme Court, the Supreme Court is a little bit tired of these healthcare cases. I actually think that's why I was so surprised that they granted the Medicaid work requirements case. Sort of why do that now? If things are going to be reviewed, things are going to be looked at. Why reach down and take another case? There is another Medicaid case that the court might take, which is there's a different split in the lower courts. And when lower courts are split, that's when the Supreme Court usually weighs in. There's a split in the lower courts involving when individual patients can sue state Medicaid programs to have access to providers of their choice under the Medicaid program. And it comes up very frequently in the context of abortion. And because it comes up in the context of abortion, it's possible the Supreme Court does have an appetite. The newly constituted Supreme Court does have an appetite to reach down and take that set of cases. But that would also have a very large implication on the Medicaid program if the Supreme Court were to suddenly say, well, there's very little that patients can do to sue the Medicaid program to enforce their right to pick providers of their choice. That would be a very big change in Medicaid policy, one that I think a lot of advocates are worried about. But I think the PBM thing was kind of a surprise, to be honest, and I am really looking forward to digging into that opinion.
All right, thank you.
All right, and so we'll go from the west coast of Florida to the west coast of the United States. Assemblyman Cooley of California.
Very good. Professor Gluck, you can't think of the Supreme Court without thinking about the majesty of the law. The law is this institution with such a long, rich history. At the same time, we know that there's personalities on the Supreme Court. Of course, you clerked for Justice
Ruth Bader
Ginsburg,
Ginsburg,
right?
yeah.
I actually have a letter that I got in my inbox in, gosh, almost 20 years ago from Justice Kennedy, who had taught at my law school when I became an elected official at a city in California.
Wonderful.
Do you have any thoughts on the newest member of the court? You worked with Justice Ginsburg, Justice Barrett. What's your sense of how a justice settles into that role? Just any thoughts that you would feel comfortable sharing?
Yeah, thank you so much for that question, Assemblyman. So I think the way in which we've seen the most, this actually brings me to another topic I should have mentioned. So I think the way in which we've seen the impact of Justice Barrett's ascension to the court very, very starkly has been in the dramatic difference in the court's approaches since she came on the court to the ability of governors to issue coronavirus-related legislation in the interest of public safety. So in the period before Justice Barrett ascended to the court, Chief Justice Roberts was the swing vote, the controlling vote that he wielded generally to uphold the power of governors and local health officials to regulate in the interest of public safety, whether that meant keeping church services small, whether that meant closing down businesses, and so on. When Justice Ginsburg passed on September 18th and Justice Barrett ascended to the court, Chief Justice Roberts has moved into the minority. The court has issued a series of high-profile opinions. The most recent one came out of New York involving a Jewish organization, Agudath Israel, and the Catholic Diocese of Brooklyn, in which the Supreme Court basically struck down Governor Cuomo's restrictions on all sorts of businesses, large businesses, from congregating, particularly on the grounds that they discriminated on the basis of religion. I think anybody who has followed Justice Barrett's writings or her confirmation process knows that she's been very upfront about her interest in protecting religion. And I think that is the first area in which she has clearly made her mark. It is already clear that religious liberty is getting a much larger playing field now on the modern court. And this, thank you for reminding me, because I was remiss in not mentioning to you all that there are a bunch of cases involving the Affordable Care Act that do implicate religious liberty. The biggest ones were the contraception mandate cases. The Obama administration and the Trump administration took different positions on whether the Affordable Care Act should require copay-free contraceptive coverage, even if the person worked for, even if religious employers. And that has been back and forth to the court several times. This is one of those areas, to go back to the last question, that no one would be surprised if the Biden administration went back and revisited to try to think of if they could come up with a middle ground. And there'll be litigation on that, undoubtedly. And quite frankly, the chances of that litigation succeeding are much, much lower now than they were on September 17th. I think we're going to see an approach to government power that is smaller, right? That may serve the interest of some people in some of the states well, but it also depends on how your states or individual states are approaching the issue of emergency power in the pandemic. And this is obviously one of the most important issues of our time. There's going to be vaccine distributions. There are going to be cases. We're going to see a Supreme Court, I think, hostile to strong arm influences of government power. It's problematic as a health law. My area of specialty is health law. It's problematic and a little bit scary from a public health perspective. And so I appreciate that. On other matters, we haven't really got a chance to see her in action. On the Affordable Care Act case in particular, she was very, very quiet. And that usually means that she's sort of going to go along with the flow in the sense of upholding the rest of the Affordable Care Act and perhaps striking the mandate down. But her questions in the argument mostly went to whether individuals have a right to bring the lawsuit in the first place. They were very there were small bore questions that didn't indicate that she was looking for a fight in that particular case. So I would expect she's going to go along with the rest of them in that case.
Thank you very much, Professor.
My pleasure.
All right, now to Ohio Senator Hackett.
Yeah, thank you, Professor. You've been great. You know, an issue you touched on, and I don't know what's going to happen, but you touched on the short-term plans and the association plans and the MEWA plans. See, in Ohio, as it is in the country, you know, small group is community rated, but the healthy ones can get out of that access through looking maybe at the short-term plans or looking at the MEWAs or association plans where they can be asked health questions. And so what do you think the solution? Because you're going to build a book of business of everybody else, and the Affordable Care Act gives them the ability to play both ways. So they can come in and get a MEWA or association plan, and if they have bad claims, they can jump right back in, you know, January 1. So what's a solution? How do we resolve this?
I think it's a hard question, and I actually, and you guys are much more expert in the nuances of individual insurance regulation than I am. I think what the issue is that the Affordable Care Act recognizes the need for these exceptions for these plans and try to carve them out in a small and limited way for groups that truly meet the definitions as set out in the statute. So the idea of a short-term plan is supposed to be a short-term plan. It's supposed to be a stopgap when you're moving from one situation to another. It is not supposed to be a 3-year, I'm 26, take me out of Obamacare, ramp. So I don't think the Biden administration, I have no personal knowledge on this from what they're going to do, but I don't think you're going to see them getting rid of those options. But I do think you're going to see them trying to reinterpret the regs, bringing them back to where they were closer to the Obama administration time, where they're trying to encourage local insurance officials to really scrutinize whether the plans in question meet the definition. I think the case that came out of Texas is very illustrative. The idea that internet companies who pay people to take their data, which is a common business model, could then turn around and say, oh, we're a health plan for purposes of ERISA, brings a little bit of credibility. And there's been some misuse of healthcare ministries or broad interpretations of what a healthcare ministry is that are designed to sort of pull people out of this basic insurance pool, which, as you know, the Affordable Care Act really relies on. And I think the issue is whether we're trying to shore up the Affordable Care Act or not. If you're not trying to shore up the Affordable Care Act, look, President Trump said on several occasions that these different regulatory moves were designed, in his words, to kill it. He didn't say, I'm supporting the Affordable Care Act this way, I'm making it stronger. He consistently said that these regulatory moves were designed to undermine the act, to pull people out of it. But if the Affordable Care Act is the healthcare law of the land, if that is going to be where we are moving forward, my own view is that we should, and I know it's not the view that everybody shares, and I know the statute is politicized, and I'm sure Chris is going to disagree, but my own view is that we should put our efforts into shoring it up and improving it. There are a lot of things that could be done to improve the statute. The subsidies are not generous enough. The individual out-of-pocket is still too high for many people. There are things that the Biden administration could do to make it more affordable for more Americans. That's my answer to that. It won't be satisfying to those of you who are trying to create multiple alternatives to the Affordable Care Act, but that's not the philosophy of the Affordable Care Act. It's not about having a wide array of alternatives to the market that the Affordable Care Act sets up. All of the new insurance protections, as you know better than I am, depend on this healthy insurance pool. So it's very hard to say we support sort of shoring up the statute, but at the same time providing all of these exemptions. And the last thing I'll say in answer to this question is that a big problem with a lot of these plans is one of the problems the Affordable Care Act tried to deal with in the first place, and that is the quality of the insurance offered, right? Many of these plans have very, very flimsy coverage, and that is a problem. People call them junk plans. They're not high quality plans. They don't meet the essential health benefits. And that's a problem for those of you who are interested in consumer protection and making sure that consumers who pull themselves off of the ACA exchanges in this way know the implications, that they know that they're putting themselves in a position where they might not get coverage for essential services, or they might go medically bankrupt, as was the case with so many people before the statute. So again, I know that answer is not going to satisfy everyone on this call, but it really comes down to the philosophical question of whether you buy into the basic philosophy of the ACA in the first place. And that probably defines where you fall on these lines. But as insurance regulators, you also can sniff out something that doesn't seem right. So even if you are not supporters of the Affordable Care Act, when you get a group coming to you that says, oh, we're a company, we're an association, and you're really not fitting into those categories, you know, even if you disagree with the underlying philosophical thrust of the statute, you might think, well, I'm not going to approve this kind of plan. It doesn't fit within the text. I am mindful of the time, and I realize I've spoken for quite a while, and I want to be sure to give Chris some time to talk. So what do you think we should do?
Unless there's any other questions here, if you're satisfied, we're satisfied. We appreciate you being here. And
yeah, well, I could talk to you all day, but I want to be sure that Chris has equal airtime, and I know he has different views, and it's always healthy to have a full airing of different points of view on these issues, especially when it comes to the Affordable Care Act.
well, as the author of a short-term healthcare expansion in Indiana and the Model Act here, I have different views of your last comments, but
You know, I said that completely respectfully. So thank you.
I know, Abby, that's okay. I ask you to look at our law. I think it's pretty solid. But anyway, to
Thank
avoid
you
some of
very
the
much.
concerns that you have about the legitimate concerns that existed prior. So I do appreciate you being here. And then with that, we will move on to Dr. Chris Pope, Senior Fellow from Manhattan Institute. If we,
Hi.
There he is.
Thank you, Abby, for the presentation. Thank you, everybody,
Thank you,
for
Chris.
inviting me and being here for our discussion today. So yeah, I also have a personal attachment to short-term to declare. I encourage the Trump administration to do this and go ahead with it. Suggested they explore the avenue and then broaden it and have sort of set out some principles for what it really is intended to achieve in the grand scheme of things, and how we might ensure that it isn't junk insurance, because that certainly is not the intent of the provision. But anyway, so I think I'll start just by talking about the context for the Affordable Care Act. It's really pretty unprecedented to have basically a decade of warfare on a piece of legislation, certainly in a major piece of legislation. There really hasn't been any big bill in history that people were fighting for a decade afterwards. I mean, even the Fugitive Slave Act, within a decade of its enactment, it was off the books. And so it's pretty extraordinary that it riled people up and created dissatisfaction, and dissatisfaction lasted for quite so long. Why was that at its essence? Well, I probably share a lot of people's views in sort of seeing the community rating provision as the essence of the Affordable Care Act, certainly in terms of its insurance market rules. And what the community rating provision did, obviously, is it said that insurance had to be priced the same for folks who signed up after they got sick as for people who signed up before they got sick. This obviously created a fairly problematic incentive for people to wait until they got sick before buying insurance, with the consequence that we all know that healthy people dropped out of the market. You end up with a pool of risk that was much, much sicker. Premiums within 4 years increased by 105%. And there was this desperate scramble to force people or get healthier people back into the insurance market to really try and rebalance the risk pool. And none of that really was particularly successful. The mandate certainly was not very successful. Even under the Obama administration, about 70–80% of people who were uninsured were exempt from the mandate. And the mandate penalty itself was fairly insignificant for the vast majority of people. Only maybe out of the 30 million people who were uninsured, only 1 or 2 million were subject to a mandate penalty of over $1,000. And when you're thinking about the cost of insurance coverage on under the Affordable Care Act being maybe $15,000 for a family, that's not a very significant penalty, and it never really had that much effect. I disagree a little bit with Professor Gluck on the issue that matters in terms of the protections of the Affordable Care Act is the nature of the risk pool. We have this rhetoric about the pre-existing conditions and the Affordable Care Act as a safety net and providing a degree of protection for folks. But ultimately, this is undergirded by subsidies. The Affordable Care Act's exchange, a lot of the rhetoric about it is as of an insurance market, but to a large extent, it's a defined benefit or a disguised entitlement. The subsidies on the exchange expand in proportion as is necessary to guarantee a defined benefit to individuals, the vast majority of whom are subsidized. And it's really the provision of the subsidies that have prevented the market from collapsing entirely. It is the subsidies that are really dominate this market. And we want to really think about the Affordable Care Act's exchange to a large extent as a subsidized safety net. For folks with subsidies, the Affordable Care Act's exchange is a fairly decent safety net. Certainly, if you have the more generous cost-sharing reduction subsidies, if you're below 250% of the poverty level, it's a fairly decent form of coverage. And if you're above 400% of the poverty level, if you're not entitled to subsidies, it's not a very attractive form of coverage. It certainly doesn't offer good value. Again, if you think about the combination of deductibles and premiums for family coverage, we're talking about $22,000, $23,000 before the insurance starts to pay for any hospital care of any significance. So it's not very attractive as a form of insurance that a healthy person would buy before they get sick. As an insurance market as such, it's essentially failed, and it survives really as an entitlement. And we should be clear about what's happening. The second big element of controversy that I think was significant in the Affordable Care Act was the Medicaid expansion. Now, obviously, the Medicaid expansion, if you look at the dollar figures, and if you look at the enrollment numbers involved, it's actually a little bit more than 2/3 of individuals who are affected by the Affordable Care Act, the coverage expansion, are through the Medicaid expansion. So it very much is, again, an entitlement expansion. But what distinguishes the Medicaid expansion from the previous Medicaid program or the extent of the Medicaid program prior to the Affordable Care Act is that the Medicaid expansion was for able-bodied working age adults. And so this obviously creates an enormous issue of work incentives that didn't exist for the previous Medicaid program, which was for the disabled, for dual eligibles, the elderly, and for certain sort of categories of low-income families. Certainly not the extent that it does with the Medicaid expansion. If you look at the Medicaid expansion, where does it phase out? It phases out at 138% of the poverty level if you include the income disregard. And that is basically the level in about the average state where an individual would be just above the cutoff if they worked full-time at the minimum wage. And so that's really problematic. If you're at the minimum wage and working full-time, you lose your Medicaid entitlement. That is a big problem from the work incentive point of view, and the controversy that's come out of that politically should be understood in that respect. And I think that's why it's had significant, where there's been significant reluctance to embrace the Medicaid expansion as it was initially designed, and why you've seen a number of states that have gone over to partial Medicaid expansion that have tried to mitigate the work incentive problem with time limits or with work requirement provisions that have been associated with it. So what happened? That I think is why the Affordable Care Act has been so controversial for so long. Secondarily, what did the Trump administration do? Well, obviously, in the first year, in 2007, we saw the attempted wholesale repeal and replace through Congress. But I think at some level, there was always going to be a bit of a struggle, as Professor Gluck mentioned, because of the limits of what the Republicans could do with 52 votes in the Senate, which was essentially use the reconciliation process, which was adjusting appropriations levels. So they could take money away from the Medicaid expansion, they could take subsidies away from the exchange, but they couldn't really fix the core regulations in the exchange. They couldn't really restructure the core regulatory causes of the dysfunction on the individual market in terms of community rating. And so Republicans were always going to end up with a proposal that was going to be unsatisfactory. I think in the process, they never actually got far enough to realize how they were going to be unsatisfactory, even if they had the votes, even if McCain and Collins had gone along with it. I think they would have still had many big problems just because they weren't able to fix the regulations through the reconciliation process. The second problem that they had in the repeal and replace push was more self-inflicted, which was the desire to generate savings through tax reform. For tax reform with the healthcare reform. And that basically led to a bill, certainly in the initial House version, that was defunding the Affordable Care Act without really setting up something that was better, basically living a financial black hole in the middle of it. And that created a bad public feeling that I think lasted into the Senate bill and really made the politics of it much harder. The other issue that was very difficult was the issue of the Medicaid expansion, which had been inconsistently adopted by states, keeping basically the Medicaid funding similar at the same level, but evening it out across states led to basically a huge redistribution between states. States that had expanded, money would be taken away from them and given to states that hadn't expanded. States like Arizona that Senator McCain was from, or states like Kentucky that Senator Paul was from, a lot of the no votes essentially for the Republicans came from the states that would have lost money, and I suspect they dressed it up a little bit, but the fundamental objection is they didn't want their states to lose money. And then the provision for per capita caps that was in the Medicaid expansion was again like politically difficult in terms of squeezing state revenues. A lot of the real political obstacle to the repeal and replace legislation came from that. So then the administration moved on to a regulatory track. First of all, there was the issue that the mandate repeal, which managed to go through in the tax reform legislation. There was a sort of weird legislative jujitsu, if you think about it. The fact that the mandate was repealed, CBO had scored the mandate as enormously consequential, really excessively so. I think everyone now acknowledges they were pretty wrong about that. And so that really hurt the Republicans' wholesale legislative replace initially, because the headlines in the news were tens of millions are going to lose health insurance, the number uninsured are going to spike. But in the tax reform, that actually worked out in Republicans' favor because they could score a lot of savings from the Medicaid expansion, not in having so many enrollees as projected. And so that actually sort of made the mandate repeal very attractive in terms of the budgetary politics of tax reform. It ended up ironically providing the scorable savings for a big part of the tax reform. As we saw, the repeal of the mandate ended up not really being a big deal. That was a matter of controversy at the time. But again, if you think about the exchange as primarily a subsidized entitlement, most people on there at the margin are subsidized, their premiums are subsidized. Whether the mandate is there or not ended up not really affecting the risk pool, because people were insulated from the nature of the risk pool. Certainly the people who remained on the exchange were insulated from the nature of the risk pool because they were mostly subsidized. And so repealing the mandate didn't make much difference in practice. Now, if you sort of take the attitude that the ACA's exchange is, for the most part, for most beneficiaries, effectively an entitlement, a defined benefit entitlement that is heavily subsidized rather than really an insurance market. And it has been for quite some time. It has been really since the last days of the Obama administration. Well, then the cost of basically allowing actuarially fair insurance alongside the Affordable Care Act, really the downside of that essentially goes away. And the legislative loophole in the Affordable Care Act that we were able to find was essentially the short-term limited duration loophole that essentially allowed you to offer underwritten coverage, medically underwritten coverage that essentially offers good value to people, that rewards them for signing up before they get sick, allows them to have insurance that's priced in proportion to their risk, and therefore give them good value. You can have that alongside the Affordable Care Act without causing too much difficulty, and begin to give people insurance, give people a reason at a reasonable price to purchase insurance before they get sick. That, I think, is the essence of what the short-term insurance market has essentially been able to offer. It, in fact, really regulatorily just meant rolling back a regulation that the Obama administration had introduced in November 2016, a week before the election. They had basically the 3-month cap on the duration of short-term limited duration plans was really only put in as the Obama administration went out the door. The Affordable Care Act was enacted in 2010, basically with the definition of short-term insurance being anything up to a year and no limits on its renewability at all. That had survived throughout the legislative process of the Affordable Care Act. It had survived through 6 years of the Obama administration's implementation of the Affordable Care Act. And it was only really when they were heading into their lame duck session as President Obama was going out the door that they basically tried to crack down on the short-term limited duration market, really unnecessarily, without really any benefit to the individual market at all. All it did was that the Obama administration saw that this rival to Affordable Care Act plans was becoming popular, was offering people some sort of value, and they were worried about the potential alternative to the Affordable Care Act with this theory that it was a sort of one-size-fits-all risk pool. But in practice, the short-term rule limiting plans to 3 months had no benefit. There was no benefit for the Affordable Care Act from that. The only real effect of it is to kick people off their plans after 3 months when they get sick. People actually who are still healthy after 3 months could even under the Obama rule buy another 3-month plan. So the only burden of the 3-month rule was to kick out people who became sick, and so it had basically the opposite effect that the Obama administration claimed it would have. I'm not entirely sure that there is a huge benefit to, or even any benefit at all, to reinstituting the Obama restrictions on short-term insurance. You're basically exposing people to reclassification risk without any benefit by imposing that limit. The other big regulatory change that the Obama administration did that I think was probably less controversial, certainly Professor Cook didn't mention any sort of opposition to it, and that's the individual coverage HRA rule, which allows people to basically take the tax-exempt health care benefit that is provided by employers and to use that money to purchase plans from the individual market or the short-term limited duration market. That basically enables people to benefit from the tax exemption that's always been skewed in favor of employers controlling insurance, and then you lose it when you lose your job or move between jobs, forces you to go to a different plan. With the individual coverage HRA rule, you're able to benefit from this from the employer subsidy, but then use it towards a plan that you can keep across jobs. And so you're not forever being forced to jump between plans, and you're able to select the plan that meets your own needs rather than your employer saying, this is the plan that you're going to have and you better like it. You don't really have any choice in the matter. That potentially is the most significant of the Trump administration healthcare reforms in my mind in terms of its potential long-term impact. It really potentially is quite revolutionary if it is effective, because instead of having employers tell people what their networks are, what their cost sharing is, which which insurer is going to cover them. It puts individuals in control of it and allows them to control it without gaps from employer to employer, which is potentially in the long run a big change and a big improvement in my mind from where the health insurance market has been. So what might we see in the upcoming 117th Congress? Well, I think at some level the Affordable Care Act wars are pretty much calmed down finally after over a decade. Like I think a lot of that was about President Obama. A lot of it was about the substance. I think there has been, both sides have sort of had a chance to play with the legislation, to tweak it to some extent. There might be some deals, some legislative arrangements to do with the subsidies. More money might be put on the table for those, but there would have to be some kind of element, some benefit for Republicans to come to come to the table on that. You could imagine something maybe bolstering protections for consumers in short-term insurance, or kind of bolstering renewability in the short-term insurance market. Maybe extending renewability would be something that Republicans would be willing to get in return for expanding subsidies for the exchange. If you're concerned about the short-term plans being junk, one of the big concerns is that you're basically kicking people off their plans if they become sick after 3 months, or after a year under the current regulation, or certainly at the end of the 36-month renewability. Well, if you got rid of that cap, that would really get rid of that risk entirely, and make the market a much more robust, mainstream, continuous source of insurance coverage, where people aren't sort of forced off their plans with the risk of being denied coverage due to pre-existing conditions. You could extend this renewability beyond a 36-month time horizon. That might be something that makes the market more robust and kind of protects consumers, and makes the market more effective. The other big issue, which I think is really a bipartisan issue more than versus Democrat issue, it's more of a providers versus insurers issue, is the whole issue of surprise billing. Now there is a sense in which this is a congressional issue. Congress has been working on this for a number of years, but it really is something that could be completely dealt with at the state level. Now, insurers are already required to reimburse under the Affordable Care Act medical providers, hospitals, and physicians for surprise bills in an emergency context. But the state legislatures could really just prohibit, unilaterally prohibit prohibit hospitals and doctors from sending surprise bills to patients beyond what insurers are required to pay. That really, because it's a regulation on the side of that's imposed on hospitals and physicians, that would not be subject to ERISA preemption, because you would just be regulating the hospitals and the physicians. So there are some states that have regulated, that they've basically tried to solve and managed to solve the surprise billing issue, really by addressing themselves to the provider side. Obviously, the providers who would like insurers to be forced to have an even more generous to make even more generous contributions than is currently the case, they would prefer a federal solution. But in terms of really providing the protection to consumers, and insurers are already required to reimburse at generous rates to providers for the emergency context, that can really be done at the state level. And again, you could impose a requirement basically saying that when there is an ancillary physician, or sorry, a physician or an ancillary provider, such as an anesthesiologist, that's out of network at a hospital, you could require the hospital to basically ensure that any provider that's operating within its walls is within the same networks that the hospital is. You could do that by regulating the hospital, and there would be no ERISA concerns that would preempt that. So the surprise billing issue, I think, if you're thinking about achievable legislative action, that definitely could happen at the state level, and really possibly could happen at the congressional level. I think that really was probably the most helpful one for the next year or two, certainly. So happy to open this up to questions from anybody.
All right, thank you. We're going to go to Arkansas. Rep. Ferguson, you have the first question.
Yes, thank you. I guess I'm just looking for suggestions from either of the speakers. Insurance, really the biggest problem is that insurance has just become unaffordable for a huge section of the population. I mean, you can extend the subsidies, but that still doesn't touch a lot of people that are paying so much for insurance. And because the community rating has been so skewed with pre-existing conditions and not having enough of a mandate penalty to keep healthy people on the market and then moving these healthy people to other insurance products. And I mean, I don't think anybody today wants to get rid of pre-existing conditions. It's become, very politically popular, but it has, I mean, I think it's been one of the biggest reasons for the dramatic increase in costs because you're skewing the community rating so much. But what are solutions going forward?
Well, in terms of like how to, I certainly agree with the concern. In terms of how to think about the concern going forward, I really think that the Affordable Care Access Exchange is really best thought of as a safety net for people with pre-existing conditions and who are entitled to subsidies. And for those two groups, it offers reasonably good value. It's a useful safety net, but we ought not to think of it as a market of first resort. I think the short-term loophole and the short-term market, if it can be made into a more robust mainstream market, the ability of plans to underwrite and reward people for signing up before they get sick will allow that to be a market that can provide really coverage that's priced in proportion to the costs that people are likely to face. As I mentioned, if you think about the average premium plus deductible for family coverage being $23,000, that doesn't offer anyone good value to sort of pay out of pocket. What you need to sort of create the ability for people to purchase affordable coverage through a parallel underwritten market. The short-term market offers the first sort of green shoot for that, but it needs to be expanded and it needs to be made more robust regulatorily. And certainly the renewability provision has to be expanded. The cap on that has to be lifted. I'm somewhat optimistic that Congress might be able to help in that respect, and certainly the risk of it being made worse can be avoided.
All right, thank you for that. Yeah, I think underwriting is an interesting thing because it led to pre-existing conditions getting people kicked off or not able to get coverage. It's looked at as a bad thing, but unfortunately, without underwriting, we haven't incentivized health at all in our healthcare system. And so I don't know if we ever could see a point where even ACA plans would have the ability to underwrite and charge at different levels based on health, but certainly we need to build some incentive in there for people to live a healthy lifestyle. With that, we'll go next question to Assemblyman Kevin Cahill in New York.
Thank you, Martin. This isn't so much as a question as it is a direction to my colleagues. I'm actually involved in multiple Zoom sessions today, and I was pulled away for a few minutes, but it appears to me that at some point, Professor Gluck was asked a question about the Rutledge versus PCMA case, and she gave a response. I just want to draw everybody's attention to her chat revision of her response. She indicated that she took a quick look at the case and sought to revise her answer. So her revised answer is included in the chat for all of you to see. It is a very important case. I know in New York, we perceive it to be ERISA to be a significant hurdle toward addressing the issue of the uninsured in our state by creating a New York State universal health plan. But the professor seems to share the same sort of expansive view that we all did when we read the case yesterday. So just for your information, it's in the chat. That's all.
All right,
Kevin,
thank you for that.
Read it out loud, Kevin, for those that are in the room in Tampa, because Matt actually asked the question. He's in the room.
Yeah, that's what I was going to ask. Can those of you that can see the chat, those of us here cannot see the chat.
Let me read it to you. This is from Professor Gluck. I did just take a quick look at the ERISA case, and I want to revise my answer. I do think the court opened a door to say that state reforms that primarily aim to address cost rather than plans would not be preempted. And Justice Thomas's concurrence emphasized a more careful and perhaps less expansive reading of the text of ERISA that would result in less preemption. And then she goes on to thank everybody and indicates that she regrets not being able to stay to the end, and offers to have anybody that wishes to reach her at Abby, A-B-B-E, period, Gluck, G-L-U-C-K, @yale.edu.
Thank you, Kevin. I appreciate that. And
Yeah,
I-
thank you
I-
for that update and reading that. That's good news, I think.
It does. It's going to open up some further discussions as we move forward. I guarantee you that.
Yeah. Yep. Okay, next up, next question, we have Rep. Jim Gooch from Kentucky.
Thank you, Mr. Chairman. And Mr. Polk, let me thank you for really pointing out some of the real reasons that some of us actually refuse to talk about the Obamacare and actually call it affordable, because really there's nothing about it affordable. And then I think one of the things that we struggle with is that, we all know that there were some small number of plans before that maybe really weren't insurance, that was sold as insurance, and they really weren't good plans. But I think what we've done here with this act is create some really great plans. They have unlimited lifetime maximums that cover pretty much everything. But we don't really understand that it doesn't help to have a plan available to you that no one can afford. And that's what we've done. We've created these plans that really are unaffordable unless you were able to get subsidies or you qualified for getting something for free, like the Medicaid expansion and that sort of thing. But we have to understand that so many people that I've seen out there, they, in order to have insurance at all, they had to go to the really high deductible, high copay plans that really had a lot of out-of-pocket costs. They really weren't as good a plans as they had before, but that's really basically all they could afford. And as policymakers, when we move forward, it's not helpful that one group looks at us and says, well, you're really not considering consumer protection, and you really don't care about, all of these folks, when actually we do. I mean, affordability and even having insurance is a consumer protection issue as well. And when you allow people to sign up for a policy, to wait till they get sick to buy something, or have to buy a plan that they really can't afford, or can't afford it without high deductibles and really high co-pays, is really not a benefit to folks. I know that's not necessarily a question, as it is a comment, but I guess maybe any ideas is what we can do to bring the conversation forward, that yes, we do consider and we do care about consumer protection, but it doesn't just involve forcing someone into a plan that provides benefits maybe that they don't need and really don't want to pay for. How do we do that going forward? Thank you.
Yeah, I think it kind of comes back to the issue that you need to give people some kind of discount for signing up before they get sick. You need to be able to reward people for getting into the market early while they're healthy. And I think it's probably like kind of getting away from this notion that there's this pool of healthy people over here, the pool of sick people over there. The point of insurance is that people are healthy and sick at different times, and and the market's going to be viable, and so long as they're in the market both early when they are healthy, and then later on, and not just later on when they're sick. And so it's a longitudinal issue so much as a cross-sectional issue. And Australia actually sort of had a situation, and they really dealt with it pretty straightforwardly. They had a problem with community rating, very similar to the one that we had with the Affordable Care Act, which was causing premiums to spike, people waiting till they got sick before signing up. And so what they did is they basically said, you're going to have a discount if you sign up before you get sick and then maintain continuous coverage. And what it did is it didn't just help rebalance the risk pool, it actually increased enrollment in their private insurance market by 50% and sort of prevented lapses in coverage. It got them closer to universal coverage because people wanted to sign up for the discount and to lock it in over time. And I think that's the way that we got to start thinking about getting the market to work. It's really giving people an incentive to sign up early, rewarding them for signing up before they get sick, which means identifying whether they're doing so or not. And that is really the point of medical underwriting, and it does have a valuable part of the process that needs to be explained. The problem that we faced before the Affordable Care Act is that if you don't sign up before you get sick, you get nothing. But now that we have the exchange as essentially a safety net for folks with pre-existing conditions, I think it actually does make it easier to, alongside that, create a benefit option or insurance plan option that essentially is appropriately rewarding people for getting in there early and giving them the value in return for doing so.
All right, thank you for that. I agree. We see it in the life insurance industry. We've got guaranteed issue all the way to fully underwritten with super preferred rates. I think underwriting could be a really valuable tool. I am curious, Dr. Pope, what are your thoughts on federal drug pricing reform? It appears that, like virtually everything else in the Senate, legislation to curb these drug prices have stalled amid partisan gridlock. President Trump did recently issue an executive order on the issue, but short of any legislation passing, their impact remains to be seen. Will states have to lead on this and on drug pricing reform efforts, do you think?
Yeah, I mean, the way I look at the drug price issue is that we actually it's actually more of an insurance issue than it is a drug price issue. If you actually look at drug costs over the past 10, 15 years, they've been rising much slower than hospital costs or physician costs. If you look at real per capita drug spending, it's actually fairly flat. The problem is that deductibles have been rising. And what is the routine medical expense that most people are incurring every month of the year? Well, people aren't going in for inpatient surgery every single month. Certainly most people aren't. But a lot of people, especially as they get older, do have prescriptions. And so the pain from high deductibles is being felt in terms of drugs. And as drugs are sort of like the #1 routine medical expense, they're the most transparent price that's out there. No one really kind of knows from week to week, month to month, what inpatient surgery is. But drug prices are very visible and very routine expense, and so that is where a lot of the anxiety is being felt. It's basically due to out-of-pocket costs. If you look at the out-of-pocket costs for hospital care, only 3% of hospital expenditures are paid out of pocket. But in terms of drugs, it's something like 15, 16%. And so it's a much bigger part of the expense that's out of pocket. And as we have a lot of these new specialty drugs that are coming on the market, a lot of the costs of treatment for modern cancer therapies, we're talking about hundreds of thousands of dollars. If we have an outdated drug benefit design insurance that doesn't really think about drugs as an insurable expense, you end up with individuals being on the hook for these enormous out-of-pocket costs. And our insurance benefits aren't really insuring people against drug expenses in the way that they have against hospital expenses, and that we do have a sort of a lag in how we think about insuring people from drug costs that hasn't really caught up with the reality of a lot of the costs for the new therapies that are coming to the market. My view is essentially that a lot of the new drug therapies are worth paying for, but we need to ensure, and certainly if you think about the cost of the drug therapy relative to a major hospitalization, even a very large drug expense can seem fairly small relative to a sort of more outdated hospital procedure, and yet we're underinsuring people against the drugs relative to the hospitalizations. And so we need to sort of modernize our insurance benefits. That's obviously for the plans to a large extent. There's a Medicare component, a Medicare reform component to this that sort of hardwires high out-of-pocket costs, so that seniors are more exposed to out-of-pocket costs than other folks. If you look at who is it that bears out-of-pocket costs for drugs, who is it that consumes drugs, it is to a large extent seniors, because as people get older, they are on more prescriptions than people of working age. So there is a real Medicare problem here, as well as narrowly sort of a price problem. I'm not entirely convinced the price as such is so much of a problem, but I definitely understand why constituents and especially seniors think this is a big problem.
All right, thank you. Are there any other questions in the room or on Zoom? Anybody want to jump in? All right, Dr. Pope, we thank you very much, and thank Abby Gluck also for being here. I know she's off now, and I think, unless anybody else has some parting comments, that'll wrap this up, and that'll give us a few minutes before at 3:15 the Life Insurance and Financial Planning Committee will start. Thank you.
We're going to begin the next session on Life Insurance and Financial Planning Committee business. And first of all, let's identify legislators who are Zooming in today on the Zoom call. Would you please identify yourself?
Pam Hunter from New York.
Kevin Cahill, New York.
George Kaiser, North Dakota.
Senator Jim Seward, New York.
Jim Gooch, Kentucky.
Bob Hackett, Ohio.
Assemblyman Ken Cooley, California.
That must be it. And we have just a few legislators in the room. Identify ourselves, please.
Andy Zay, State Senator, Indiana.
Mike Gaskell, State Senator, Indiana.
Paul Etke, Minnesota.
Thank you. I'm Travis Holdman from Indiana. Here as immediate past president. I just told someone, and I think I'm going to be the longest serving immediate past president of this association history. But I want to extend a special welcome to George Kaiser and Jim Seward, who are on the call as past presidents of the association as well. And good to see you both, if not in person, but electronically. So first of all, just to take care of some housekeeping business, we need a motion to waive the quorum requirement. Can we get a motion?
So moved.
We have a motion. Do we have a second?
Second.
And we have a second. All those in favor say aye.
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 All opposed, same. Motion carries. We need a motion to approve the September 26, 2020 committee meeting minutes.
I so move.
We have a motion. Can we have a second?
Second.
And we have a second. All those in favor say aye.
Aye.
Those opposed, motion carries. We'll jump right into business today. First of all, on the topic of accelerating life insurance innovation to create meaningful change, we have Brooks Tingle, President and CEO of John Hancock Insurance. And Brooks, thank you very much for joining us today, and let's get started and proceed. Brooks, the floor is yours.
Great. Well, thanks so much for having me. I'm happy to take any questions. I think hopefully most of you are familiar with the journey that John Hancock has been on. We occurred to us a few years ago that one's life insurance company should care an awful lot about a customer living a long, healthy life. I've joked before that in the range of people that care about you living a long, healthy life, once you get beyond immediate friends and family, I think your life insurer cares more than anyone else about you living a long, healthy life. And it struck us as fundamentally odd that for hundreds of years, we would underwrite the daylights out of people. And I had the opportunity to lead underwriting earlier in my career. And oftentimes we would know more about someone's health than their own doctors. And we'd see something in their underwriting file and say, hey, you should go see your doctor. This result looks funny. So we get to know the customer's health so well give them their policy, but then sit back and say, sure, hope that customer lives a long, healthy life, but do absolutely nothing to help achieve that outcome. So it occurred to us that we should be trying to do things to help our customers live longer, healthier lives. And I'll just, as a historical note, it's not actually a new idea. In the 1930s, John Hancock had a program. At the time, most deaths were attributable to communicable diseases, and things like hygiene and so forth were very important. John Hancock had a program where it would send nurses around to customers' homes, the old debit customers' homes, and teach them proper practices for maintaining hygiene to not spread communicable diseases. Turns out the American Medical Association got cranky about it, said we were infringing on their territory, and we shut down the program. But it's not a new idea that a life insurer might want to engage with their customers and try to help them live a longer, healthier life. So we did that. We partnered with this company from South Africa called Discovery Vitality to bring that to life, and have just seen really phenomenal results over the first 5 years of offering our customers the education, the incentives, rewards for taking steps to live a longer, healthier life. We're not trying to turn every customer into a marathon runner. You may see that I'm not running marathons these days myself, but it's really made a big impact on our customers' lives. And I would say it's also making an impact on our industry in terms of how we're perceived. We're not about just being there for death. We're about being there during the customer's life to help them live, again, a longer, healthier life and give them value while they're living. It's been really apparent during COVID that this is the type of solution we need. During COVID, we've seen demand for insurance, life insurance go up. People are more aware of their own mortality, and we've seen a much greater awareness of the importance of one's baseline health. So we've seen demand for these types of solutions go up. I'll just a couple closing things before we turn it over to Q&A. We built on that a year or so ago by coming out with something called John Hancock Aspire, the first and only life insurance built for people living with diabetes. The population of folks living with diabetes in the US is large and growing, over 30 million, 80-some million pre-diabetic. We had surveyed those customers, and over half of people living with diabetes in the US think that they cannot qualify for life insurance. The reality is the majority of people living with diabetes do qualify for life insurance from our underwriting, and oftentimes at very good rates. So this product, again, gives people incentives and rewards, education support for controlling their diabetes, and a lower premium if they do. So anyways, a lot of innovation for us around the ownership experience for life insurance. We've gone from interacting with our customers once or twice a year as we send them a bill or an annual statement to now 30 to 40 times a month. We're interacting with our customers through this Vitality program. The only other thing I would say is the next big wave of innovation, I think, for us and our industry is around the buying process. If you think about life insurance, certainly as we thought about it 5 years ago, it's hard to find a product that's less fun to own and harder to buy. Fun to own, you had peace of mind, that's nice, but it's always the thought of dying. We've tried to make it more fun to own with the app and the games and the incentives and the rewards and Vitality. Now we have to make it easy to buy. I would challenge you to identify a product that's more difficult to buy in our modern economy, in a world where consumers are thinking about one-click buying on Amazon or whatever. People have to go through weeks and weeks of underwriting. I joke that buying a home is difficult, but your realtor generally doesn't ask you for blood and urine. We do, and we make people fill out 30-page applications and so forth. So anyway, sorry, I've probably gone on longer than you'd care for, because I know we want this to be a discussion, but trying to make life insurance fun and engaging to own by helping people live longer, healthier lives, and making it a whole lot easier to buy.
So Brooks, let me ask you a question. If I purchase a policy from your company, what are the next things that I might anticipate are going to happen to me with this Vitality program? What's the follow-up with a new policy owner?
Sure. Great question. We made an important decision a couple of years ago. When we first started offering Vitality in 2015, it was an optional benefit. In 2018, we said every customer that buys a policy from us is going to get some sort of these Vitality benefits. There are two types of Vitality. crudely, I would sort of think like Amazon Prime and Amazon. There's Vitality Plus and Vitality Go. If you elect Vitality Plus, you receive your policy. You're invited to register into the program. Assuming you register, you're then given the choice of claiming a complimentary wearable device, a Fitbit or an Amazon Halo now or something like that. Or you can participate in our very innovative Apple Watch program. I wear many devices, that's part of the job. You can participate in our Apple Watch program that I can describe more. The key thing I would say though is that you don't have to do any of that. This program is all about carrots, not sticks. Sticks do work from a behavioral science perspective, by the way, but if you buy a John Hancock policy and choose not to use Vitality, there's no harm. Your underwriting doesn't change, your price doesn't change. But if you do, you get to claim a complimentary device or participate in the Apple Watch program. You download the app, you start sharing whatever information you're comfortable sharing, how many steps you take, whether you went for a preventative screening. You sign up for our healthy food program that offers customers 25% discounts on healthy food purchases at over 17,000 grocery stores. You just kind of go into the ecosystem and start taking advantage of all the education and tools and support to live a longer, healthier life.
How do you measure success then? What method do you use? What markers do you look at?
Well, long term, our most pure definition of success is, are we helping people live longer, healthier lives? You all know more than enough about our business to know that the true answer to that won't come for decades, right? It takes a while for this mortality experience to emerge. In the short term, the markers we look at are the indicators of improved future mortality. And I'll give you a couple examples. Physical activity. Our customers are taking on average over twice as many steps a day as the average American. Preventative screenings. We all know that as we hit different ages, depending on whether a man or a woman, there are different screening procedures you need to go to. The colonoscopy at a certain age, this at a different age. Not surprisingly, many Americans don't adhere to those guidelines. Our customers, because they get points for those activities, do adhere to those guidelines more. So we know our population of customers goes for those screening activities more often than the general public. So we're watching those indicators that will correlate to improved mortality. Improved mortality is the economic fuel that drives, that supports the various rewards and incentives that I mentioned earlier.
You mentioned briefly about the pandemic. What challenges did you see with the pandemic, and what was the response that you folks put together?
Yeah, the pandemic, couple thoughts. First of all, and I'm sure it's something you guys have discussed, a tragedy on its face, but as somebody who cares passionately about our industry, it's really dismaying to me to see how many people are dying from COVID that don't have life insurance. It may seem weird for a life insurance company CEO to say, I wish we were paying more claims, but I wish we were, because that would mean more of these folks passing away from COVID had life insurance. I sit in my home office, as we all are these days, and I see the ticker of the number of deaths, and I think about our market share and think, oh, we should have this many claims. Well, we have a fraction of that because so many of the people dying from COVID simply don't have life insurance. So that's created sort of a call to action, I think, for our industry. I know for us to say, how do we reach more Americans so that they don't, whether it's from COVID or something else down the road, don't die without life insurance. As it relates to the Vitality program in particular, we did have to change some features. One way that people can earn points, and I'm sorry, by the way, if you don't know how Vitality works, just 2 seconds. You get points for doing things that correlate with a longer, healthier life. Taking steps, seeing the doctor, buying healthy foods, meditating, getting a good night's sleep. It's like a frequent flyer program for healthy things. You get points, those points accumulate, determine a status. That status determines how much of a premium discount you get and the value of a bunch of other rewards. Well, one way that people earn points in the program is through a gym visit, by going to the gym. We could see almost overnight in March, as things started to close down, varied by region, we saw gym visits dropping quite sharply. Now, we knew who was earning points by going to the gym and we contacted them and offered them an alternative means of earning points. It was a kind of a fun thing. Just take a selfie of yourself working out at home and we'll give you the points like you went to the gym. We sent everybody, this was kind of a fun thing, we sent everybody a John Hancock Vitality face mask. And a number of customers said, you know, it makes sense that my life insurance company sent me a mask, right? Like we want to help people live longer, healthier lives. We did a virtual 5K, virtual John Hancock 5K. So we've had to respond with different elements of the program. We've seen certain rewards consumed less than a normal year. One of the rewards is a discounted hotel stay through hotels.com. No one's using that right now. We've seen the healthy food benefit go down a little bit. People going to the grocery store a little bit less often, it seems, maybe. I'm not sure what that's all about, but it's been great to be able to react and change elements of the program. We've been able to serve our customers a lot of information through our news feed and so forth about COVID, and people are much more interested in. We've actually seen engagement in the program go up because people kind of get that the more healthy I am, should I get COVID, the better outcome I'm likely to have. We saw a survey, one of our reinsurance partners did a survey of US consumers and said, what's one thing you're going to do differently as a result of COVID? 70% of the people said exercise more and lose weight, which I wouldn't have guessed intuitively, but kind of makes sense if you're watching COVID outcomes and see the correlation between baseline health and your success fighting COVID.
Very good. Interesting program. Are there questions for Brooks from any of the members?
Mr. Chairman, Jim Seward here. I had a question.
Yes, Jim, go ahead.
Yeah, for Brooks, did I hear you correctly when you said that one of the impacts of the pandemic has been an increase in interest and demand for life insurance as people think about, I suppose, thinking more about their own mortality? And my question is on the innovation theme. You know, for years we had heard about the shortage of producers out there, and my question is there any thought of in terms of more innovative ways of not only marketing but also, you know, reaching potential new policyholders and getting them signed up for life insurance, other than the, shall we say, the traditional sitting across the kitchen table with an agent?
Yeah, well, thank you, Senator. Great questions. On the first part, we have seen an uptick in demand for life insurance. Applications to our company are up nearly 10% this year versus last year. And industry-wide, maybe not up quite that much, but industry-wide, there's been an uptick in interest. And, you know, unfortunately, it takes a global pandemic to get people to think about their mortality. But these events, we actually tend to see it after a lot of events. After 9/11, we saw an uptick in demand. These things that get us thinking, gosh, something could happen to me. What if it did? Am I prepared? So yes, an uptick in demand, but also an uptick in people thinking about just their overall health, which has caused people, I think, to be attracted to this vitality solution. Great question, Senator, about distribution. You know, I mentioned earlier my dismay that so many Americans are dying from COVID without life insurance protection. And part of that, there are a lot of reasons for that. Sadly, you know, a third of the population just has such pressing financial pressures, they can't think about, you know, another check for life insurance. They got to worry about putting food on the table and rent and things like that. But for other Americans that kind of know they need life insurance but don't have it, it is, I would say, part distribution. Are we connecting with customers? We don't have enough boots on the ground, if you will, of the traditional card-carrying insurance agent to find everyone and sit across from the kitchen table. We have to have new ways to reach them, whether it's through the work site, whether it's through digital methods, online, associations, what have you. We have to do more of that. The other big barrier to people not having enough life insurance, I am convinced, is the burdensome buying process. I mean, you have to really I don't know who on this call has bought individual life insurance lately, but man, you got to really want it to get it because it's only in I'll tell you a quick story. I was actually out in California presenting to a group of like venture capital, fintech people about Vitality. And they were all probably like early 30s age wise. And about 12 of them came running up to me after I presented. This was obviously pre-COVID. And they said, Tingle, I never even thought about life insurance. I thought life insurance was something my grandparents had, or maybe my parents. I never thought I'd own life insurance, but I want this Vitality thing. It sounds really fun because there are games in there and everything. But every one of those people, Senator, that was talking to me had their phone like this, and they all said, how do I get it? What do I do to sign up? And you can imagine me trying to explain, I was trying to dress it up the best I could, but I'm like, well, we're going to introduce you to an agent and you're going to fill out a 33-page application. And then they're going to ask you for your blood and urine. And then you're going to wait 6 or 7 weeks. And then we'll hand you this stack of paper and we'll get you going. And I tried to explain it better than that, but that's kind of the process. And you could see the body language, like the phones went in their pocket, their shoulders shrunk, and they said, you know what, Brooks, we'll follow up with you. You know how many followed up with me? None of them. So I'm convinced that one of the reasons a lot of people don't have the life insurance they need is just so darn difficult to get. So I think you'll see, and you guys will be a part of this, I'm sure, you'll see a whole wave of innovation coming relating to that buying process, use of electronic health records. Why do so many of us as patients or consumers now have on our phones, we have an app with our health records right on them. This crazy process we go through today where we go to the doctor's office and say, hey, send us a copy of John Doe's medical files. We wait for it to come and then we dissect it. We did a survey of US consumers to say, would you be willing one-time limited use access to your electronic health records? Would you be willing to share your electronic health records through an app if it meant getting life insurance in days instead of weeks? 60-some% of the people said yes. So you'll see a whole wave of innovation around that buying process. Some you're going to have to be careful about as legislators, as in your regulatory bodies, because there's a lot of data out there. And you'll hear a lot of people talking about the use of big data to predict mortality outcomes. And I'll tell you that you can do it pretty accurately, but for fairness reasons with consumers and things like that, like I'll tell you, I've got data scientists that if you just give me somebody's name and birth date, they can predict with about 94% accuracy how a traditional underwriter will underwrite a case with all the traditional inputs. But we're not going to underwrite that way, because what do you say to a client? The client says, hey, John Hancock, you didn't give us your best rate. Why not? Traditional way, we can say, oh, it's because of your blood pressure or your this or your that. Am I going to look at them and say, oh, it's because our predictive algorithmic underwriting model scored you a 68? What the heck does that mean, right? So I think it'll be an interesting issue for you all, again, as you think about legislation, as you think about the work the regulatory bodies in your state do to make sure the industry uses data responsibly, because we do have to radically improve that buying process. It shouldn't take weeks. It should take, moments or a day or two, right? With the right information, but we have to do it responsibly. You're going to see actors out there because the data can be quite predictive. I'll tell you a quick story. Years ago, there was a company running around saying they could predict mortality and morbidity based on your cable TV bill. Now that sounds crazy, right? But it's not true now with all the cord cutting, Netflix and all that. But years ago, when there's cable, your cable TV bill as a percentage of your income, it didn't work at all once you got to like 150,000 of income. But if you make $35,000 a year and have a $250 a month cable bill, the logic was, well, gee, that says a lot about your lifestyle. Now the model wasn't just your cable TV bill. It was like, a whole bunch of other inputs. But anyways, that stuff actually kind of works, but it's not stuff we should be using for underwriting, in my view. In my view, the best path to a more timely experience for the customer is some of the traditional sort of legitimate medical information as inputs, but just obtained much more efficiently, obtained electronically, acted on more quickly. So sorry, that was a big digression from your question, but they're important questions because, we do have, this industry does have to innovate. you know, the growth rate in our industry has been like 0 or 1% the past few years. Maybe it was 4% last year. That's like nothing when you look at inflation, right? And we know our products and solutions are valuable. So we have to make it easier to buy. We have to make it more fun to own, but we have to do it all the right way.
Thank you, Brooks. We have time for one more question for Brooks, and the chair would recognize George Kaiser.
Thank you, Mr. Chairman. Brooks, one of the things, as you were talking about the quick access with the phone and that sort of thing, it reminded me of a problem we've encountered here. And that was that agents came to me very upset because of the time it was taking to get medical records from hospitals and providers. And I was amazed that these providers had arbitrarily expanded the time frame to almost 4 weeks. Yeah. And that resulted in really significant problems for selling of life insurance. How big is that problem?
Well, it's been a particular problem during COVID, right? Like our industry's reliance on these traditional practices of a paramedical exam or an insurance exam or tracking down those files at a doctor's office, as there's been strain on the healthcare system. You know, frankly, doctors' offices have things that are better to do, presumably right now, than ferret out copies of people's records for insurance processing. So anything that slows the process down is bad for the customer, is bad for the company, is bad for the agent, right? Because the agent doesn't get paid unless they make the sale. So that's why we think utilization of the electronic versions of those records can be so powerful. And it's not like we're getting any more information than we used to get or that we're entitled to. It's just getting that same information much more quickly without the agent having to chase it down, without the doctor's office having to copy it or whatever they do, and without all the delays. So it's always been an issue. It's become a bigger issue, I would say, this year during COVID. And I know we are trying to move in the direction of utilization of electronic health records much more.
Thank you. I just had one quick question for you, Brooks. What is the level of insurance face value that you purchased that you are not required to do the paramedic screening for all of that? What is that number these days?
It varies by company. You know, I'd say it's generally at carriers getting up to the range of a couple million. It depends on your age as well, but say below 65, we're starting to getting up to a couple million. I think you're going to see sort of an arms race among carriers to see who can underwrite the highest amount, the oldest person with the least information. We have to do it responsibly again, but I think that will be good for consumers if carriers do it right. Easier to get, easier for people to have the protection they need.
Thank you, Brooks. Appreciate your participation today.
Thank you.
Very meaningful discussion.
Thanks for your interest, everyone.
Sure. Next, on the topic of regulatory challenges and temp to permanent efforts in a touchless society, Jordan Martell, Vice President of Innovation Council for Pacific Life. Jordan, welcome. Glad to have you here today. The floor is yours.
Thank you, Chair Holdman, and thank you to the members of the committee for this opportunity to present to you. I'm going to share a brief slide deck with you that we'll walk through. So I'm going to hit share screen now, and hopefully this works, or it's going to be an interesting presentation. All right. So I'm going to enter into my slideshow mode. Are you seeing the slide or just the slide with the talking notes also?
We see a whale.
Just one whale. Okay, perfect. That's what you're meant to see. Thank you very much.
Okay.
So as I mentioned, my name is Jordan Martell. I'm Vice President and Innovation Counsel at Pacific Life Insurance Company. Pacific Life is a 150-year-old mutual life insurance company. And my topic today is on modernization efforts in a touchless society. As we go through, you can see this is the before and after COVID beard growth. So my agenda, I'm going to provide a little bit of background information. We'll touch on innovation, in particular, the topic of artificial intelligence, and in particular, why are we talking about artificial intelligence so much? I have a few answers to that that I hope will be interesting and helpful as we then turn into modernization efforts, looking at regulations, laws, and other practices that may need to evolve as consumer sentiment continues to shift and modernize itself. So first up, we'll touch on some background information. So when I say background, I mean way in the background. I have here a slide that some of you might recognize from history class. On the left-hand side, we have Homo erectus, which is a species of human that existed for about 2 million years. And we have Homo sapiens. Everybody's familiar with that guy. He's around today. That's each and every single one of us. And the reason I'm starting here, because I think it's an interesting conversation and a parallel here. So by many estimates, Homo erectus was the most successful human being to ever walk the earth. As I mentioned, that species lasted for 2 million years. And by comparison, we today have only lasted for 300,000 years. And given the way 2020 has gone, it sometimes is doubtful whether we'll make it to 2 million years. And there was a time on this planet that many people don't know about where actually multiple species of humans walked the earth at the same time, and they competed with each other. And that was in fact true for Homo erectus and Homo sapiens. These two species competed, and it's fairly obvious who won that conversation. So as I mentioned, Homo erectus was the most successful, lived for 2 million years. I don't know that Homo sapiens will get there. I hope we will, certainly. But where are they now? Obviously, Homo erectus is gone, and Homo sapiens looks like this today. So a slight evolution. Now, when I mentioned that they competed with each other, I think what's relevant to this conversation and why I'm touching on this topic, which may seem a little strange for many of you, is with respect to innovation. So these are the first tools ever used by Homo erectus on the left and Homo sapiens on the right. Now you can see Homo erectus existed long before we did, and they made this series of beautiful stone tools. These things in the foreground here, these 3 items, are what they call hand axes, and they were useful for felling trees, but also for cleaving tendons and meat from bones as you butcher animals. There were these beautiful stones that were carefully crafted on both sides to be quite sharp. On the right-hand side here, you can see Homo sapiens. These aren't exactly our first tools, but these are some of our very first tools. We got some pointy, stabby things. We've got a splintering tool here, which is good, again, for cutting meat from bones. So you can see we started with similar ideas for tools. Now, Homo erectus, their most recent tools they use. So for 2 million years, they started with these on the left. 2 million years later, they're still using the exact same tools. Exactly the same, no innovation whatsoever at the Homo erectus species. Homo sapiens, by contrast, as you can imagine, our most recent tools look like this. A little bit more sophisticated than the stone tools and the flint that we started with. Now, is it surprising when you compare these 2 final images that we're still here and Homo erectus is not? In fact, I put forth to the committee that innovation is a central thesis of the human Homo sapiens survival and a central piece of the way our minds work. It's in our genes. It's why we're here today. In short, survival requires innovation. And this is true not only at the species level, as I've demonstrated here with Homo sapiens versus Homo erectus, but this is also true at the corporate level. Here's a few numbers for you. More than half of Fortune 500 companies have disappeared since 2000. So in the last 20 years, if you looked at the Fortune 500 list of 2000 and looked at it today, you'd find about 50% of the same companies. In 1960, the average lifespan of a company on the S&P index was 60 years. Those were companies that had been around for a long time by the time they reached that success. Today, the S&P index is made up of newcomers. Our average age of companies on the S&P index is only 15 years. So these newcomers are supplanting the traditional powerhouses in the industries very quickly. This last stat is a quote or an estimate by McKinsey. It's 2020 today. McKinsey, the consulting company, estimates by 2027, 75% of today's S&P 500 will disappear. Again, this speaks to the need for legacy companies that want to continue to serve their consumers to do so and to embrace innovation to the maximum extent to meet their consumers where they are. So that's a little bit of background. As I mentioned, it went farther back than any of you might have guessed. We've talked about modern humans versus Homo erectus, but now I'm going to turn to this topic of innovation in artificial intelligence. And in particular, I get this question a lot as Innovation Council. People will ask me, why do I keep hearing so much about artificial intelligence right now? So there's three reasons for why we're hearing about AI, why we're talking about it, why we're having this presentation right now. The first one is what I call the formula for artificial intelligence. Now, when I say the formula for AI, I don't mean the math formula for AI. There's actually nothing very new about the mathematics that underlies artificial intelligence. That's been around since the 50s and 60s. What is new, and the reason why we're talking about artificial intelligence and the formula that I call it, is really the formula of data is the first element. Here I've got a chart that shows the explosion of data over the last 20 years. And so to summarize this chart in a key stat, the estimate is over 90% of all human data ever created has been created in the last 2 years. So if you think back to the Bible, to the Mahabharata, to Homer's Iliad and Odyssey, to the works of Shakespeare and John Milton, to the horrible loss of the burning of the library at Alexandria, all of that amounted to less than 10% of human data created. And 90% of that has been in the last 2 years. So part of the formula for AI is data. And a corollary necessary component in the formula for AI is computing power. So what I have here is a graph that kind of demonstrates what's sometimes referred to as Moore's Law. And Moore's Law says that the computing power of a microchip will double every 2 years. And so far, as you can see, going back to the 70s when computer chips were new, that law has happened. And you can see we're really in the hockey stick edge of the growth of computing power. So if this doubles again, I don't need to tell the people on this meeting about the power of compounding interest, but it's really working in the favor of stronger computers. So together, data and computing power are here, and they are fueling this drive in AI. Now, an important aspect of this, other than the formula for AI, is funding. We hear a lot more about AI because, frankly, there's a lot of money there now. This is a chart from 2019. Obviously, 2020, the venture capital funds were a little bit different. But in 2019, you can see there was $26 billion invested in startup AI companies. So this is the number of deals on the right. So over 2,000 deals and, like I said, $26 billion. So there's a lot of money there feeding off all of that big data and all of that strong computing power. But why are we also talking about AI now? If it were as wonderful and simple as I've laid out, we wouldn't have much of a conversation about it. But the truth is, and I think all of us we need to acknowledge this, AI has problems, and that's why we're talking about it. One of the problems is data breaches. Now, I mentioned AI needs big data in order to be powerful. Well, with big data comes big responsibility. And unfortunately, we're seeing a growth in the number of consumers impacted by breaches and the number of actual breaches happening. So that is something that I think we as a society, we in the industry, and we with our legislators and regulators really need to take seriously. Related to AI problems, another one is the acknowledgement and the discussion that's happening today around the way that artificial intelligence can sometimes perpetuate inequalities. If you're relying on big data, and if that big data has bias in it, and you put that big data with the bias into a computer, it shouldn't surprise anyone that the result of that equation will be a biased equation. I know that many of you at the NCOIL conference had a long conversation about this recently, so I won't belabor the point, but I will mention proxy discrimination has been a hot topic recently. There's been a lot of discussion about this, and that discussion is being teed up again because we have the data, because we have the computer power, we have the funding, we have the ability to run AI. Now we need to grapple with the way to do it responsibly and to determine what data is acceptable to put into AI and what data is out of bounds. So I'm turning now to discussions more about the modernization efforts in regulations. And I want to take a moment here to lay a little bit of background to demonstrate a consumer trend that I think is important to the conversation here that we'll have for the remaining moments. First, I'd like to just point out this graph here that I have. Now, these are kind of unfortunate colors, so I apologize for that, but you can see this kind of limey green color. At least that's the way it shows up on my monitor. This is the adoption in the United States of America of the landline telephone. So you can see in 1903, we started with about 10% of people had a landline. It got up to 40% by about 1930. So that takes about 30 years to get less than half of the people using landlines. And it drips down a little bit, then it juts up to a peak in about, let's call that 1970. So it took the landline about 70 years to reach the point where it had maximum market penetration. It's relatively flat after that. And you can see it drops off here. We'll talk about that in a minute. So it takes 70 years for most American homes to get the landline, and we never got to 100%. So I think that's an important fact to keep in mind. This yellow or yellow type color here, this is the adoption of electrical power in the United States in homes. And you can see here, it spikes a little bit higher, but it does taper off. And it takes about 60 years to get to the point of market saturation where it flattens. And electrical power in homes in the United States too never actually reaches 100%. And I think that's an important factor to keep in mind. We still have homes today that do not have electric power. Now, I'm going to contrast these data points on electric power and landline with consumer adoption of more recent technologies, internet, smartphone, and tablet. And you can see these are almost vertical lines. They don't take long. If for instance, look at tablet, that started in about 2008. And by 2019, it was still on a vertical rise like that. The point here is that there's a large trend of consumers that are hastening the adoption of technology, in particular, communications technology, the internet, smartphones, tablets. People love these. These are where they want to be communicated with. These are the technologies that they embrace in their everyday life. They take them with them wherever they go. Now, by contrast, I find this to be slightly funny. I'll just share. If you go back to 2000 right here, so the internet's just barely taking off. It's gotten to about 20% of market penetration, 2000. This is when the federal e-sign law was adopted. In 2000, when e-sign became law, the fax machine was still the predominant way of communicating other than US Postal. Email was not really widely spread. Text messages were unheard of. Smartphones were not to come along for a number of years after that. Shortly after 2000, when e-sign came into effect, the SEC issued guidance on records retention, and that guidance to this day still refers to the use of microfiche. So a lot has changed in the world of technology since 2000 and 2004 when the microfiche guidance came out. Very few of your companies today that you'll meet are still using microfiche, but all of them now are using internet and related technologies. So there is this consumer adoption of technology advancing, and that was only hastened acutely in March of this year. So March of this year, something happened. I think everybody knows what I'm referring to. Here's a chart that I really love that talks about what happened in March. This is a chart that shows the use of the phrase times like these in quarterly earnings calls. So you can see sometime about first quarter of 2020, CEOs started using the phrase times like these a lot more than they ever had in the past. Another great graphic way to demonstrate this, March 21, this is what a New York subway looked like on the left, March 22 on the right. So something happened very dramatic. And finally, one more here. Here we have a young couple out on a romantic hike in post-COVID world in what we call a touchless society. To put it a little bit more realistically, probably looks like this. Instead of flowers, he's brought a 12-pack of toilet paper and some hand sanitizer. The point is of this, that in addition to the larger trend of consumers moving into the digital space with great haste, we as a country have moved almost overnight into a work from home touchless society. And this transition has provided us with it's basically been a proving ground to demonstrate that many of the technologies that we've seen consumers adopting are good for business, and they are good for consumers because they meet consumers where consumers want to be, which is in an online, digitally enabled world. Related to this touchless society and COVID, of course, there are a number of temporary accommodations that have been issued to the insurance industry that have enabled us as an industry to continue to serve our customers and to serve the communities where we operate. And so there's an effort underway to look at some of those temporary accommodations that have proven successful under the acid test of COVID and use this opportunity to really make those permanent. So I'm going to touch on a few of those modernization efforts now. First of all, an important one, I think, is the electronic delivery of documents. As I mentioned, the e-Sign Act, for instance, came into place in 2000. Many of the seminal technologies that transformed our country the first time and enabled the new waves of growth and industry and connected people across the entire continent, all of these technologies are now encapsulated in a person's smartphone. And here in Southern California, we sometimes have wildfires, and I can virtually guarantee that if I have to leave my house in a hurry because of a wildfire, my wife, my kids, and I, we're all grabbing our smartphones. Not all of us will have the time to grab important papers and documents. Now, I think this is an important thing to consider because, as I mentioned, very early legislation like the e-Sign Act and some of those that came around 20 years ago before the smartphone was even a twinkle in Steve Jobs' eye, those early laws presume that paper has some inherent superiority over digital. Now, there are some advantages to paper, but there are also advantages to digital. And I think it's important that consumers have a choice of where they get their documents. If they want them on their smartphone, where they can take them everywhere they're going to go, where they can interact with their brand, as Mr. Tingle just demonstrated with the John Hancock Vitality product. If they want to interact with their brands that way, we need digital capabilities and we need to enable that. So there are a number of trends looking at e-delivery. I'll mention at the federal level, the Department of Labor and the SEC are both making efforts to begin a dialogue around advancing e-delivery and delivery of documents. There's in the Senate today, the federal Senate, the US Senate, there's an e-Sign Modernization Act put forth by Senator John Thune. It's not very clear what will happen with that, as many things in the federal Congress and the Senate are moving a little bit slowly under the current circumstances, but there are models out there to demonstrate what an e-Sign Modernization Act could look like. And importantly, I'll mention that the Federal Advisory Committee on Insurance recently provided feedback to the Federal Insurance Office, asking them to explore barriers to e-delivery and to examine issues of access to e-delivery tools. So I think e-delivery is one space where there's a lot of room for improvement, to try to meet consumers again where they are, to think about those vertical spikes in growth and adoption of internet, smartphone, tablets. That's clearly what consumers are telling us they want. And if we want to be able to meet them there, I think that's important. Related to that is use of electronic signatures and notarizations. Now I have two images here. On the left is an old painting. It's from the 1600s. And in fact, that is a notary process happening. So you can see notarization's been around a long time, for hundreds of years. And even before that, you can imagine, you've seen it on TV, probably in the movies, the image of the king melting wax on his envelope and pressing his seal into the hot wax with his ring. It turns out wet signatures, all of humankind for a long time has been concerned about the security and authentication of wet signatures. That's what notaries are meant to do. Well, today, to the extent that we achieved some level of confidence in wet signatures and the notary process, today we have technologies like the iPad here that I've demonstrated, where a person can have an authentication software that uses their IP address, their thumbprint, and a personal PIN code, and to be fairly strong authentication that their signature is in fact their signature. So there's a lot of room for growth between the antiquated in-person notary process and what new technology has enabled us to do. A number of states have tackled this issue through executive order and regulatory initiatives as well. I do believe some of the temporary accommodations regarding remote notarization, those are important things for us to consider as an industry, because to Mr. Tingle's earlier point, life insurance is a hard product to buy. And if we can make it easier and more digital, and if that's where we have consumers, that's a way that we can expand access. I will point out, however, there's a bipartisan bill in the House right now, the US House, called the Secure Notarization Act of 2020. Again, I'm not sure where that's going to go, but it provides a model for what it could look like to modernize this structure. Relatedly, also, as I mentioned, FACI, the advisory committee, provided comments to the Federal Insurance Organization, asking them to look at the use of e-signature and to enhance the ability of industries to leverage these new technologies. Finally, I'll talk about some in-person requirements. I think this is great. This is a picture of a bar exam in place in early 2020. So not that long ago, we were still doing many forms of examination in person. So some genius said, hey, let's move from in-person exams to computer exams. This is what a computer exam facility looks like. So obviously hasn't solved the social distancing aspect. Yes, they're using computers, but they're still there in person. Today, however, there's a great number of technologies that enable us to perform things in person as well as we would on a computer. Zoom is obviously one of them. Many of us are here on Zoom versus being in Tampa with the NCOIL conference. But there's a number of examination technologies that allow the California bar, for instance, has shifted to online computer examinations of would-be lawyers. So the shift in technology and meeting people where they are has allowed us to really revisit as an industry in-person requirements. And so I would point out that there's been a successful trial this year in 2020. A number of states have offered relief from in-person market conduct examinations and financial exams of regulated interest industries. And I would say that we've had a chance to try those in a way that we never had before. And I think as a society, and hopefully you as legislators, we're all getting more comfortable because we have now proven technology that can actually protect the process of examination, that can protect those branch exams, that can protect the licensing exams, and do just as well as it would be in person. And I would actually argue that an online exam or branch exam has an advantage over an in-person exam because inherently all the data has to be digital. And if you have digital data, I can talk to you all day about the way we could feed that into a computer to streamline your review process and to make that examination more dynamic based on the ability to use AI. So those are a few of the modernization efforts underway. Again, touching on, as I mentioned, e-delivery, e-sign, and in-person requirements. I do want to pause and open it up for any questions, comments.
Jordan, thank you. Very interesting. I'll have to admit, I was just thinking, I need to get this printed off so I can have a paper copy. And you're thinking, why did I spend all this time telling these folks about these things when somebody says something stupid like that? So are there questions from any of the members for Jordan? Very interesting presentation today.
I'll jump in, Travis.
Sure.
This is Assemblyman Ken Cooley out here in California with you. As you look at this imperative of change and the evolution, you've mentioned the e-sign law. Are you seeing other places where trends that may be afoot that would impel change are bumping up against legal frameworks that present problems that impede the change. And one can go back, you know, the history of change in the 60s, everybody put their money into banks. Banks paid just a little bit in the way of interest. We hit a period of high inflation in the 70s. Money market mutual funds appeared. People started moving their monies out of the banks where they couldn't get much interest to gain a little more interest. That led to the term disintermediation, as the bank, the intermediary, is seeing all their money get sucked out. And eventually that led to all kinds of consequences, but it's change was afoot and you were bumping up against existing structures, and it upended and changed whole industries. So e-sign is an area. Are there other areas where you sort of see we could be bumping into change issues?
Yes. Thank you, Assemblyman. That's a fantastic question. And I completely wholeheartedly say yes. The answer is yes. Disintermediation is still a very real issue, and you can ask any taxi cab driver in the state of New York, and many in the state of California as well, although we had some legislation around that recently. So disintermediation is still very real. And as I pointed out, the need to continue to innovate for us as legacy companies in the industry that want to continue to serve our consumers is more important now than ever, because as you pointed out, technology is changing, but regulations are not changing as quickly. And so I mentioned e-sign, I mentioned notary, I mentioned e-delivery of documents, but you can also look at things like the TCPA, which is federal legislation on texting. That was designed when it used to cost you 15 cents every time you got a text message. That's not true today. And it doesn't also contemplate uses of technologies like Snapchat and some of these other messaging technologies. So although those technologies present regulatory challenges, I think there are a number of areas, both with respect to burdens, regulatory burdens that impair the ability of legacy corporations like Pacific Life Insurance to compete with some of these startup would-be disruptive companies. I mean, if you look at, just not to belabor the point, but app-based driving, that was illegal in many states. And they launched those technologies notwithstanding the laws in place. And because consumers wanted that, those companies have been successful and the laws have been forced to shift, or in some places we've had to push back very hard against those corporations. Is that helpful?
Yes, indeed. Thank you.
Are there other questions? When I think back, I authored the no texting while driving legislation in Indiana back in 2009. And at the time, we were being told that there was maybe about less than 20 apps that you could load onto your phone back in the dark ages of 2009. We just passed hands-free legislation this past year, because now we don't even know what that number is, because they're being developed every day, but there are tens of thousands of applications that you can download on your phone every day. And so it's a changing society and everything that we do electronically. So other questions for Jordan? Jordan, thank you. Very interesting, and I'll get a copy of this printed off for my file, and we'll go from there. So thank you very much. Really appreciate your time today.
Thank you for the opportunity.
Intriguing information.
Thank you.
Thank you. With that, is there any other business to come before the order today? Hearing none, the chair would entertain a motion to adjourn. We have a motion. Do we have a second? We have a second. All those in favor, say aye.
Aye.
All opposed, same. With that, we are adjourned. Are there any housekeeping announcements we need to make? We'll see you in the morning, folks. Thank you all. Appreciate your patience today.